Muted. Okay. All right. Let me pull up OnlyFans. Was I muted the whole time for all of that? All right. We overslept, both of us, like champions. I woke up. It's like 8:05. I'm like, oh my God. I had the alarm set. I think I drifted back off. It's been a tiring experience. Getting ready for the wedding. A lot of moving parts, but I'm surprised Mandy didn't like panic start the live. Like, where are these people? All right, let me see here. This will probably be the only time that Bev ever started on. Nope. Oh, perfect. Perfect timing. All right, good. It's her three stupid questions. We made it just in time.
Those same three questions, were you all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no. We should. Is Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
Doctor, I remind you, you're still under oath. Thank you.
Thank you. Good morning, Dr. Russell.
Good morning, Your Honor.
Our national treasure, Dr. Russell.
Yeah.
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd.
He's blocking the jury.
In this case?
He's blocking the
I believe
jury.
it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
And I said, okay. And you answered.
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Lessie.
And Mr. Leslie, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so did Mr. Leslie help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential diagnosis.
And so after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
testified to. You want to
Yes.
see it again?
Yes.
Okay. By the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Lessie.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the
didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order
Hey, there you go,
mandates that
Hank.
you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I did
order
not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday. No. Not in the car yesterday. No.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver. Yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just a sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride home, back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some concept. There must have been some context. He didn't just turn to you talking about the weather and say, "Hey, you should ask for a transcript." You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he
Asked
tell you
and fucking answered,
Not
pimp.
this morning.
Okay. Does anybody need to remind you to be honest with your
How
testimony?
many times does he
No.
have to say it?
What
How
else
many
did
times does he have to
how did it
ask?
come up?
It's not going
Hey,
to change
by
the
way,
answer.
Ask
I-
for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
You have any memory issues?
No.
May I approach?
Yes.
Oh, she was so offended by that. Wow. Oh my God, did you see that?
Since
I'm
you've asked
fucking
for the
rewinding
transcript, I
that.
have it for you.
No.
Context of the memory issues?
No.
Wow.
May I approach?
Wow.
Transcript.
Now he's pissed her off. Okay,
Since you've asked for the transcript, I have it for you.
it's a bad look though.
Dr. Russell, this is June
Conversation.
21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
Wow.
That looks consistent.
I can't believe he asked her if she has memory issues.
No.
She was so offended.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date,
Yes,
may I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach. Objection, Your Honor.
I'm going to strike that, disregard that, James.
May I approach?
Yes. What page you want us to?
23. June 21st, 2024, Doctor.
June 21st.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back.
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes,
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source. There is no recognized community. There's no certification. There is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. Demunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the method and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And you said you had a strong interest in dogs. And that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
Wow. He's doing a real dick.
I would like to put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2,
Yes.
number 3,
Yes.
4,
Yes.
5.
Which did you call
sorry, this
4?
one,
4,
five.
5, 6, maybe.
Okay, so as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that
Okay.
fair?
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the
Do
transcript.
you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion,
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
But when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, You didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder,
Hmm.
right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, they're at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
May I approach?
Yes.
When you first testified on June 18th, doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin, and you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay. Let me see.
Thank you. That was your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes.
after your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No,
Are there different types of teeth in a dog?
yes,
Okay. The pointy teeth, the big ones, those are called canines,
correct,
and the smaller ones are incisors.
correct,
There are 6 incisors in a healthy dog on the top and bottom between the canines.
correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did the report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged. And each time I reviewed the case, I became more certain that these were from canine teeth.
So
And actually, there's other marks there, but these are from teeth.
you say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top,
Canines are some of the teeth.
upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Were you alive?
Do you remember that conversation? You said that the point of entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this?
No, I don't
that way?
recall. Can I see the transcript?
No, I don't recall that
Do you
at
remember
all.
that conversation
No.
we had? Okay. And so inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that is from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree. Yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me. Yep. Four, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for five and same for six.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr. Russell?
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny pinpoint almost lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number two, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these two scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these these two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions, Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the word that accuse has
So-
been done before.
so- Mr. Brennan, word it differently.
Sorry?
Word it differently.
Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can you
approach?
just hold 1 second? Could you please turn the fan off? Joyce, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer Blunt.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth. Weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder. And then the sentence, but I'm not sure on the second set. So this is the set that's just above the elbow. I said, I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
Hank wasn't even looking.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter of factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were
Yes.
asked, what do you think? And you didn't say without 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
I just hate him. I hate him. I hate him.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two are caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell.
Mhm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, Can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, can you put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
What the dog
Not
doing?
just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, you have the
Specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
thank
Do you
you.
have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's 2 linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside?
First of all, I'm not certain. I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it? The distances?
Again,
Objection, Your Honor.
So there was a question with that, so I'm going to let that.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And the distance between these two, have you measured them?
I approximated them, yes.
What
And
did you come up with?
visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did not.
measure them, did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper or report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with a car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So
methodologies.
if you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes. I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really think?
I'm sorry, please.
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When
There
you
you go.
first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case,
Yes.
I didn't have a lot of information. That's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of
Accident-
accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have you
Yes.
studied that before you gave this
Studied.
opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same
What?
height?
Objection.
Of Mr. O'Keefe's
Fuck, no one has
elbow and forearm?
opined where the break
did.
was.
And
What?
did you see
I don't understand
that
what's
it
happening right
matched
now.
up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations
There
of
you go.
a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on
Flatly.
January 29,
Blasting.
2022
Flasting.
at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there was several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass
Have you
in
ever
the
looked
picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the pants?
don't know if I looked at the pants.
So when you say you didn't see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
we'll come to cyberbully.
Finally. I mean, because he the objections that keep getting sustained are when Hank's making the shitty comments. Like in that particular situation, he says, which is outside of your expertise, which wounds are not. She's not an accident reconstructionist, but she's an expert on wounds. So that's what those are going. So, all right, I've been reading the chat. I'm awake. I'm wide awake. So, all right, first of all, this is cross-examination, y'all. I mean, you're supposed to hate the other lawyer on cross-examination. That's the job. Like, her entire opinion is going to be challenged. What the real question is, what I'm sitting here thinking the entire time is, why the fuck didn't Bob Alesi do this to Judd Alesi, do this to Judd Welcher? Like, why didn't he go through this kind of analysis on cross with Judd Welcher? Do you know what I'm saying? Wouldn't we have liked to have heard Alesi say, like any of these questions? Like Welcher got to get up there and just pontificate with no science behind it at all, and throw out there that tail light caused these injuries. I'm trying to get you to, this isn't about being nice. This is a trial. There's no like, you guys need to put the whole, he's being mean, he's being, like, demeanor's one thing. In terms of the effectiveness of the questions, he's been somewhat effective.
For the record, I said the jury's going to think he's being mean.
Well, if they're going to think that he's being mean, it's going to go all the way back to the beginning
And rude. And
when he
dismissive.
asked her if she has memory problems, and she gasped. So if the die was cast, it's going to go all the way back to that point. And if that was offensive to the jury, like if it's a young jury, that may not strike them the way it strikes older people, because it's offensive. It's an offensive question for, I mean, it's basically like him asking her if she has Alzheimer's on the stand.
With no basis.
With no basis. All right, go get on the live. Quit screeching in the background and just get on it with me.
I'm going to leave soon anyway.
All right, you can come on for a half hour. Yeah, I am thinking like a juror. You guys need to think like a juror. You guys are, I get why everyone in Hank is hating Hank. Like, I hate Hank. But in terms of analyzing whether or not this is an effective cross, it is. I mean, he's able to pin her down that she can't say things with a reasonable degree of medical certainty. And And I saw people saying that, Garrett Wing, I don't give a shit if he's an A-type personality, if he's an alpha dog. It doesn't what is he going to stand up there flexing on the stand? That's not how this thing works. Okay. This is about people getting on the stand, giving an opinion, and can that opinion be challenged? That's why I'm saying it sure would have been nice to see Judd Welcher get hammered by Alessi about how in the world the taillight caused any of those injuries. Not just one of them, any of them. Because what she's saying is collectively, you keep trying to ask me individually if this wound could be, could have happened from a dog, whether it be incisors or whether it be claws. I've always kind of privately thought, I don't know why she's stuck on the teeth thing. To me, a lot of them look like scratches. I've always said if it was a dog bite, that what it would have been. But again, it's my theory. My theory that this was when John was already on the ground makes it a lot easier to answer the question is why there's no bottom teeth marks, why the grip didn't happen, because the bottom of the arm was on the ground. So I don't know. You guys, if this jury doesn't know anything about it in terms of the details of the case, I'm just telling you, this is but Lily, so when he's asking a question over and over, it's because she's not saying yes or no. I mean, the defense attorneys do the same thing. They'll ask it repeatedly until especially if it's a yes or no answer. I don't know that he has lost the jury. I mean, this is kind of like a big thing for the defense's case. I don't know. We'll have to see. I get why everyone's annoyed, but to be honest with you, you're annoyed because it's somewhat effective. See, if you have a situation where the dog pulled him down to the ground, I think that there would have been a grip nexus.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
There you
do you
go.
know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds. Did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
By the same car. What the fuck does that mean?
I don't even understand the question. If you don't understand the question, ask them to rephrase it.
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people
Oh.
and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way.
Does
Yes?
he really want to
Yes.
use the word?
Another person could have
Wildly.
a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries. Correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes. Many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes. I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you con-
several different
Sorry, she needs to answer.
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down. And so, yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
How
In
could she?
The cases that you went to wherever you saw car collisions,
No one looked at the
some of the
debris
debris
field.
that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision
There you
impact.
go.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than
That's the
imagine,
best answer she's given.
did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian.
being.
Yes, not as a medical expert.
Can I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of
Is this guy gonna fucking say that a glancing blow, a side swipe, knocked him out of his shoes? Is that what Hank's trying to argue now? See, this is where he loses the script here. This is where you can't have it both ways. Was he knocked out of his shoes or was he sideswiped? Glancing blow. You can't have it both ways.
Mr. O'Keefe's abrasions on his arm? Were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off. Correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware. I have been aware of that. Yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat, there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be if the ground was frozen. If it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
Oh my God.
76A, please. Same question. Did you consider this piece of the debris field?
I don't understand why Bob Alessi is not fucking objecting here. What am I crazy? There is no debris field picture. That's the entire point. They didn't document where shit was found. I don't understand why he's alive. Like, to me, this is facts, not in evidence. He keeps saying debris field. Where the fuck was all this shit? I don't know where is that in the yard? Can anybody tell me? Anybody in chat? Maybe I missed this. Maybe I watched the entire first trial. I've watched half of the second trial, and I don't know a goddamn thing about where anything was found. in the yard. I have no idea. Why isn't he object? Why is he allowing him to use the term debris field? I don't understand why he is not objecting to this. A debris field, that would indicate that there was some kind of chart or graph or some kind of demonstrative piece of evidence where they said, okay, this is where evidence marker 1, 5, 7, 9, where all the debris was found. I don't understand why he's allowing him to ask this line of questions and use that particular phrasing, because there's no way for anybody to know where any of this shit was found. I don't understand it. I don't understand it.
When you were coming
It's
to your
pissing me off.
conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
It's a dangerous gambit.
Would
I'll
you take
handle
that
on a
down, please?
redirect.
Would there be any significance
I don't
in
like
your
that.
study, in the foundation of your opinion, that
Everybody.
their impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
Was it important to know if the cops
I think
broke
there
it?
needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes,
Was it important to time when that taillight was broken?
what do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2000.
Here's the problem, y'all. And I know that we tell you this all the time. You object because you're preserving an issue for appeal. Like, this isn't like, I'm going to trap Hank into keep saying, that there was a debris field, and then wait until cross or redirect rather, and then bring up the fact that there was no one piece of documentation that shows where the debris was spread out.
Well, you can't
And-
object on that basis anyway, because the Commonwealth has presented evidence. I'm
Not
going
of
to
a debris field.
of a debris field.
No, they
I think
haven't.
They have.
What? Various pictures of where shit. I have no idea where in the yard that is.
I agree, but I'm just saying she'd say they're claiming that's a debris field, so it's not like
What's a
objectionable.
debris field? Okay, pictures of various pieces of taillight found where I have no fucking idea is not a debris field.
Bob, it is in the same general area.
What, Allison? What happens if it's 15 feet away from the street?
Hey, I
On the
didn't
yard.
I didn't define the general area. Fuckface did, or obtuse asshole,
What's
or
the
whatever that
general
guy's name.
area?
It's this thing.
What is that?
That's how they
Saying that you
defined it.
can't object is ridiculous. That's
same
I
general
disagree,
area.
ma'am. I disagree, ma'am. Can absolutely object. Like, I don't think there's any facts and evidence of what the debris field is, or if there was a debris field at all.
Same.
2022. Yes?
Yes,
Early morning hours.
yes,
When you were making your differential diagnosis, was it important for you to learn whether around that time the
General
defendant's taillight was
vicinity.
broken?
Okay.
it was important to know.
Didn't matter
I
because
still don't understand the question.
right, the class
I'm
didn't
having
do
a
it.
trouble
Okay.
understanding
these
the
were
It's
question.
my fault.
plastic
I'll try to ask it a different way.
injuries.
You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes,
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
that's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes,
And you learned that her right rear taillight was broken and missing pieces. Yes?
yes,
Did you want to know if there was any evidence depicting when that taillight was broken? And considering this conclusion,
yes,
did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, a car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Miss Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time?
A broken taillight in and of itself could not cause those injuries.
Thank
There would have to be multiple projections from the vehicle that were lined up
Thank
in a
you.
certain pattern to
Finally.
give those parallel marks
Ugh.
all in the same direction.
Thank
So,
you.
Doesn't
you know,
matter.
that's why a broken taillight could not have done that.
Thank
So
you.
in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Doesn't
Oh,
matter. It
after.
doesn't matter because the
So you had
taillight
already
couldn't
arrived
cause
at your
injury.
opinion, then you received new information, which was that ring video, correct?
Doesn't
And it
matter.
confirms, yeah.
And then you received more information. Did you receive
That
photographs from
information
the
doesn't
dash
matter either
cam
because the taillight couldn't
during a
cause those
wellness check
injuries.
showing the defendant's
saying
Lexus missing
Keep saying that.
pieces of her
Please.
right rear taillight at about 8:03 a.m. that morning?
Would that be, I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential
like,
diagnosis?
it's not
I
a
think I've
video.
seen that picture before.
Sorry.
The
Could we
car,
have-
the vehicle parked, yes.
Exhibit 11, please.
What the fuck?
Did you consider this picture in your differential diagnosis?
I
Hank,
didn't, I
do
don't
you
know that I ever
understand
saw this picture.
Differential
Seeing this-
diagnosis. I mean, does he why is the judge allowing him to ask these stupid fucking questions? Did you see this picture? She has just testified. Essentially, I could give a fuck when the taillight broke because guess what, Mr. Brennan? Broken pieces of taillight didn't do this. It would take multiple projectiles coming from the vehicle. So did you consider this picture in your differential diagnosis? See a like super like professional witness that this is, I am one tracked on keeping everything exactly the way I want it to be because I've been paid to say this and I want to get paid again to say this, would answer something along the lines of, again, well, damn, I had it in my mind, but it's gone.
Keep going.
Keep going. Testosterone time. Wait, I think it was something like, give me 1 second.
The nice mustache. Yeah.
Something like,
Could have a mustache battle.
I don't know. I mean, it was obviously along the lines of like, so I don't care about the taillight being there, but it was much better than that.
Right. I mean, the bottom line is that she has reached a conclusion that the tail light, because of exactly what she just finally answered, which I'm sure Bob was going to get out of her on redirect, but that a tail light could not have caused those injuries. Like she described like that Matrix thing where it would have had to have exploded and like stopped in midair in order for his arm to hit there and then hit there and then hit there. You know what I mean? It's like all the rest of this shit doesn't matter. None of this matters. Like I don't need any of that because I started from the place of, okay, a tail light isn't causing those injuries. It doesn't matter how he was hit.
Right.
It doesn't matter where his body was in the yard. None of that matters. All I know is that a tail light did not cause those injuries.
Yeah, and I'm sorry, Mr. Brennan, but a differential diagnosis doesn't take things into account like what that picture looks like. And I think where I was going before I like fog brained up was that I would say that, you know, first of all, differential diagnosis is medicine, sir. And if I'm looking at these other pictures and I'm considering these outside sources, this brings us back to your earlier question about confirmation bias and using information that's not relevant to my medical opinion to fill in the blanks about what could have, what might have happened. Uh, period. Like that's what I'm paid to say what I want, what they want me to say, and I want someone else to pay me again later, as we saw with their Dr. Welcher, the kind of answer that he would give right here. I mean, she's just being honest and answering the questions, you know. But there's a way to stick this question so far up Hank's ass that he would choke on it.
Well, and the other takeaway is, why didn't Alessi ask Welcher any of these types of questions with respect to his premise? Like at all.
I heard you say that earlier, and I've been thinking ever since he said that every question that has been being asked, I was thinking about how it could have been, you know,
Opposed to Welcher.
Yeah, but it's just like, because most people don't think to be a slimy. I know you see it as just a real good cross-examination, and how it lands dictates, I guess, whether it's good or not. But in my opinion, I sure as shit hope that these jurors are thinking, I've got fucking eyes, and this guy is trying to make it seem like she's not seeing what I'm seeing, and that she's not saying that from a medical position, this is what she sees. I think it's possible the jurors are being like, I don't like that fucking stupid question because I've got eyes and I understand what she said. And I feel like even if they don't, grasp it all, that they feel like that question doesn't seem to be on point with what she's telling me. And especially if we got some like engineers or like people with knowledge, they're like, this guy is gaslighting us. I feel like that's how the jury could feel.
Well,
from
when they're going to feel like they've been gaslit, it's not right now. When they're going to feel like they've been gaslit by Hank is after Wolf and Rensler get up there and they explain what polycarbonate is and how it breaks. And it breaks in big pieces. It's not going to shatter into a million pieces with tiny little sharp. Like the concept of like the micro pieces being embedded, which they're not using that term anymore, I've noticed in this trial, but being found in John's sleep, like that is not how polycarbonate plastic works. It breaks off in big pieces. So when they're going to put together, they've been gaslit by Hank, it's when the ARCA guys come on and testify to that. But right now, I'm still just sitting here wondering why the fuck Welcher wasn't hammered.
One of the questions I was thinking after you said that, and obviously we all know, we've said it before, talking heads say it all the time, you're not supposed to ask a question you don't know the answer to. But I was thinking about how me personally as a lawyer would have been tempted to ask Welcher about, in the same way he's like, well, didn't you want to know there was a minefield everywhere? Well, you didn't know at that time that the two of the later
debris field,
refused
minefield, or debris
oh
field?
debris field, right?
Like what?
I don't know, stuff
we
about
just go into like a wartime type
I know.
situation.
I was going back to that, like the concept of the glass on the thing, resting on the bumper, the double vision glass that's not associated with any piece of glass, that when Alessi was asking those questions, the guy was like, well, yeah, I mean, if it has nothing to do with this glass, I'd still like to know how it got there. And even at that time, I was like, well, just ask him why it's so important and be like, well, if there was some evidence that, let's assume maybe it was planted there, or he was placed there by a cop involved, or maybe these other pieces. Oh, I remember. So I was going back to your question. I was thinking the same thing he could have done. He could have said, Alessi could have asked Welcher, if you took this injury in isolation, there was no debris, there was no piece of glass, there was no pieces of this, would you be able to say that in and of itself is consistent with a car accident? And he would have had to say no.
Right.
I don't know, but it's easy to say that, but you're not supposed to ask a question you don't know the answer to. And that guy isn't the guy to do it with, because he was the guy that would just keep it. I want to be paid. I got paid now. I want to be paid again. I'm going to answer in a way that's fucked. So it wouldn't have worked. So unless he's a better man than I, because I would have been tempted.
Picture, do you see that the right,
Oh,
do you consider this picture in your differential diagnosis?
I got to leave you guys soon.
I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear tail light is missing pieces?
Objection.
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
It's not something I should even consider, Hank. It's
You
not something I
had,
should be considering.
As a police officer, when you're excluding the source, in this case, you're saying the
Where am I going?
cause of Mr. O'Keefe's scratches on his arm could not have been from a collision. Do you listen to witness testimony?
I don't love that she just said that she noticed the taillight's missing.
I know.
Or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about?
Did I hit him?
Did I hit him or something of that? I don't. What do you mean specifically?
Have you seen any of the media statements
Man, he's
by the
supposed to
defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a
Say
impact
no.
or collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction.
Ha ha. Take that.
Very
Hank.
common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can
Talk
last
him.
years.
Pause it.
It's usually
Pause it.
it's very brief, but it can last years.
This is exactly why he is not allowed to use those fucking clips out of context. He's acting like she was still thinking it a year later when all the clips he's using is her explaining why she said it that night. This is a fucking outrage. I
Yeah,
hope he
well,
feels
I mean,
gaslit by that, but I don't think it's going to come back to bite him. I'm
it's
not
gonna
sure. That,
it's gonna have to come. It's gonna have to come on summation. Exactly what you're just saying.
but they
Yeah.
don't have the if they don't get those other pieces of the video in, the report in, God, the interviews in, they don't see that it is her explaining. I was yelling that when he used it. When he closed with that video, I was like, fucking bullshit, because
Well, how do they do that?
they have to get in the earlier portions.
How?
I think it's under the
Completeness
completion
doctrine?
doctrine. Completeness doctrine, yeah.
I don't know. I don't know.
All right, you
I mean,
guys, you've
I
had me for
agree
9 minutes.
completely. Everything being taken out of context is fucking insane. I don't know how they're going to get him in, short of her getting on the stand.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Some of the yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have exhibit 147B, please?
Look at your
On the
chat.
right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor, like approach, please.
Okay, come on up.
Babe, check your text, because it sounds like he's asking for a mistrial. He's been pointing and screaming and yelling
Whoa.
on the sidebar. Tracy's
Who's
sending us
he?
Alessi. Tracy's sending us updates.
Okay. Wait, Tracy's sending us spoilers?
No, I think it's things that when there was a last sidebar, I think it's what, or it could be a spoiler.
This
I
is
don't
sidebar
know.
right. This is the sidebar right here.
No, but
Oh,
she sent it
shit.
a while ago.
All right. So let's see what
I think it
everybody
was a
looks like coming
previous-
back. All right, so they're about to walk back from this sidebar.
It's taking longer than any of us wanted to.
is a spoiler.
So we're going to continue what we're doing, but we will give you.
Sorry.
So
It's
that's
about to happen.
about a half an hour. Okay?
Obviously,
please.
I thought it was old shit.
if we didn't see it, then obviously it's
Bloop, 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 bloop.
all right. We're about to find it out here.
Fuck, I gotta leave.
See ya.
All right, Mr. Alessi, I'll hear you.
Damn right.
Mr. Alessi, I'll hear you.
Ugh, Jackson's like, I wish it was me. And she's like, oh, yay. The kids told me where I'm going. I forgot. Forgot the place I'm
Mr. Brennan,
headed.
can you remove? Oh, okay, it's being removed.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has
That's
been
not happening.
no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced and direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of
gotta go.
DNA.
I'm watching the
With
background.
regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we are going to, or we always intended to bring on rebuttal, Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you. Mr. Brennan.
Fiery.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper. It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions. where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you, Your Honor.
Mr.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds to of the right arm of Mr. O'Keefe. That is a major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, not to leave swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
Irremediable, you mean?
Sure.
I don't know about this, though.
You don't know about what?
Well, let's
The
do it.
defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcripts, and this is the December 22nd, December 12th, 2024 transcript. I direct the court to the direct examination of the attorney who
forgot
just
to offer it so far.
of raising it for the first time.
What
Despite his
page-
words,
what page
we
are you
have
on?
page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour. So
All right.
So I was just listening to you before I got on, and I must have been behind, which I guess I was. So to me, what I understand is happening right now is that the defense team has decided that since during the Commonwealth's case in chief, they didn't introduce a DNA analysis, that DNA was taken, that the existence of DNA at all. Sorry, I'm following directions here. That they were not going to be able to mention it in rebuttal. Is what I'm taking. Like, they decided collectively, like, all right, they fucked up. The Commonwealth didn't put it in at all. They didn't put it in DNA analysis. They didn't say DNA was taken. They're not going to be able to bring this up on rebuttal as much as they think they are. We're going to have an objection, and our objection's going to win. Is that the sense that you're getting, babe?
Yeah, I mean, because they didn't bring it up in their case in chief, and just so you guys know, we talk about this all the time. That the Commonwealth's rebuttal is tailored only to what the defense brought up during their case in chief. It's not like, oh, this is the shit we forgot to put in during our case in chief, and now we're trying to introduce it. It has to be in direct rebuttal to something that was brought up or raised by the defense during its case in chief. And that's what Allison's saying. I mean, the defense isn't going to touch that with a 10-foot pole.
But
and now they're trying to get it in. But there's two bigger takeaways. One, because if you'll remember, the only kind of DNA they found was that weird pig DNA, right? So they didn't introduce any of that evidence during their case in chief. The Commonwealth did. None of that came in. They didn't put on the witness who, and they only swabbed the sweater or the hoodie. They didn't even swab John's wounds.
Right, but did they not even put that in, babe?
That's a bigger deal than.
But that's the question, babe. Did they put on evidence that they even, so far in this trial, that they even swabbed those areas for DNA?
No, I don't believe so. I don't think that came out.
So go, and I guess that's the defense's point. But so go on. I didn't know if I missed something.
Well, to me, that's a much bigger point with respect to they didn't even swab the wounds, and him bringing up DNA or the absence of it with relation to the hoodie itself is incredibly damaging in terms of the minds of the jurors, because immediately, I mean, let me just ask you, what are you thinking if they didn't find DNA? If he brings up they didn't find DNA, canine DNA on the hoodie, what's the next logical leap that you're going to take as a juror?
Right, that it wasn't a dog attack.
That there was no DNA in the wounds. Okay,
I mean,
that's where you're coming. Like, I mean, I'm asking you to take that short logical leap. It's a very short logical leap. Well, if there's no DNA in the hoodie, that means, because that's what the fear is from the defense. That's what the fear is that the mention of it is going to lead them to the point where they're thinking that, because the jury doesn't know.
But that's easy.
That the wounds weren't swabbed.
Right, but isn't that easy to rectify on?
I mean, yeah, but like, we just don't know like what effect things have on a juror in terms of, can you unring that bell? You know what I'm saying? I mean, I hear what you're saying. Yeah, well, they can just get somebody up there that says, well, they didn't even swab the wounds. So maybe there was. But I think she's not going to grant it. She's not going to grant it. There's, so, but again, you have to raise these issues. You have to ask for the mistrial in the event that Karen was convicted, and you have to appeal. You've got to raise it, because I think it would be a really big issue on appeal. I mean, we all know, like, DNA is the magic evidence in trials, even though it shouldn't be. But with jurors who watch, the SVUs and, all the crime shows, and like, everybody thinks that DNA is the end all be all, and it's merely just a piece of the puzzle. But that's not the way that normal people think about it. So I don't know.
My phone is cutting out, so I can't tell if you finished. I don't want to start saying something if you're mid-sentence.
Oh, well, yeah, it's got to be your phone.
I know, but so here's what I was going to say, though. The defense has now brought up the fact, presented evidence, it was a dog bite. I think they get to rebut the case the defense puts forward, which would allow them, I think, clearly these four lawyers don't think. That's why I started this by saying
they have decided between themselves with putting great thought to it that the prosecution missed a step and they're never going to be able to get this in on rebuttal. But I don't see why they wouldn't be able to both put a DNA analysis on and their expert to say it wasn't a dog bite, both in rebuttal. That's what I'm not. Did the judge say something? I heard her ask for what page is it on, but do you think that they shouldn't be allowed to do that just because they forgot in their case in chief to even mention the fact that DNA was taken?
I mean, they didn't put it into evidence.
I know, but if
DNA was taken from, they did swabs on the hoodie, and the Commonwealth elected not to bring that in. They could have. And Hank's answer for that was, oh, well, we made a conscious decision not to challenge every ridiculous theory of the defense. So, right. and that is not stopping us from mentioning it. And that's where this argument lies, is whether or not the fact that they have introduced something that they didn't put into evidence at all in any way, shape, or form on cross, whether that's fair game.
Right. And in my mind, and again, I'm not saying that I'm right, that's why I started by saying it's clear that they put a lot of thought in this, and they've decided, the defense team's decided that because the prosecution didn't even mention taking DNA, whether they gave the answer yet or not, like they don't need to give the answer. It seems like they're saying because they never even brought it up, that they don't get to bring it up on cross. But in my mind, it does seem directly to rebut the defense's case. But like I said, I would need to give more thought to it. But yeah, I mean, I don't think she's granting it under any circumstances, and they're definitely preserving it for the record. But it's clear that in their war room and in their, like, that they've researched this issue and they felt damn sure that they should win an objection once the prosecution tried to do it because they missed a step. But now they might rectify that step in rebuttal, and the judge might let them,
Well,
or
I
maybe
think they're certainly going to be able to put a witness on to rebut Dr. Russell. But specifically the issue, I mean, clearly they can put on anybody that they want that they feel can rebut her testimony in terms of the pattern of the injuries. But that's a different question than this DNA thing. Because I like, in terms of what Alessi's saying with respect to whether or not if it's irremediable harm, then can a curative instruct? Because it is damning. I'm telling you that by way of.
But isn't it fairly rebuttal? Isn't it fairly rebuttal though?
Wait, what? What is what fairly rebuttal?
Like, is Brennan making a valid point that he didn't have to bring it up in his?
Not if the defense doesn't bring it up. Because DNA is different than wound patterns. Like, they didn't introduce anything about DNA in their case in chief at all.
Right, but if he's saying that it's, I guess the question becomes, is it fairly actually rebutting her, because I guess you got to look at it more.
No, it's not, because there was some kind of animal DNA found. Like how, if they didn't bring it up during their case in chief, the Commonwealth, and the defense doesn't mention it, how in rebuttal are they just bringing in new evidence that they should have brought up in their case in chief if they wanted to argue it?
The fact that even DNA was taken, or the fact that there wasn't dog DNA. I think it's the fact that DNA was even taken is their issue. I think.
Well, yeah. I think it's both. I don't
Well,
think
yeah,
they're
but
mutually exclusive. I think that you had to have brought up the fact that the thing was swabbed, the hoodie was swabbed. And, you know, I think that you have to bring up the fact that there was some animal DNA found, namely a pig.
right.
So,
All right, I'm
I-
hanging up. I'm going to be listening, but I won't be able to chat or anything. Bye.
bye, love you. Yeah, I don't know. Like, I mean, the pig DNA thing was fascinating to me. I mean, I don't know about all of you that have doggos, but I mean, our guy's like one of his favorite snacks in the world is pig ears. They have them at the butcher. They're big and disgusting, and he loves them. You know, I mean, it's like I think I think it creates a real. Do I think that she's going to grant a mistrial? No, I don't, because she's Canoni. I think it is a severe issue. I think that on if she's convicted and they took that because this is a like a really huge area, right? Because it's directly connected to the tail light. It's like it's the defense's explanation for the arm injuries, which is far better, far more believable than the Commonwealth's theory for the injuries, which we still don't know what it is. Like that's what I was saying during this cross when I paused it. I'm like, why? Like, and I was screaming about it during Welcher's cross. Like, why in the fuck are they asking the questions that need to be asked about how in the world can you explain to me, like I'm 5 years old, how in the world the taillight caused those injuries? Explain it to me like I'm a child, please. And like just grilled him on it. He never would have been able to come up with an explanation for it ever in a million years because there is no explanation for it. And if he would have come up with some fakakta bullshit, it would have been like the jury had been like, what? So, well, it depends. I see this question here from Mel. If it depends, if it's with prejudice, the case is done. If it's not with prejudice, they could bring the case again. So if a mistrial is declared, this trial would stop immediately in its tracks, goes away completely. But if she doesn't put the magic words with prejudice at the end of it, she being Canoni, then the Commonwealth has the ability to be able to bring the case again. If she says, I'm declaring a mistrial with prejudice, case is over. I can't bring it again. It's dead in the water. So, you know, and obviously, and that's where the part where Bob was talking about it being irremediable, that means that they can't cure it. That her coming out and giving a curing instruction is not sufficient. Meaning that's like where, you know, it's that thing where you're telling the jury to pretend like they didn't hear what they heard. Like in all of us, just as regular people, forget being a lawyer, just be a normal person. You can't unring bells. It's like I say it all the time. Like that's not how the human mind works. It's in there. You've heard it. The damage is done. So, and I'm telling you that the logical leap from him saying just those words in the form of a question that there was no dog DNA that was found in the hoodie. As soon as he said that, the next thing that a person's going to think is, well, if it wasn't found in the hoodie, then it couldn't have been found in the wound. And the jury has no clue that they haven't swabbed it, any of the wounds. Yeah, exactly, Shiloh. That would be the easiest way for her to get rid of this case. That would be the easiest way. Ashley says, agree, Bob. I didn't understand why those questions weren't asked of Welcher. how is it the taillight inflicted those wounds and exploded? I mean, it drove me nuts. It absolutely drove me nuts. And then I had like a terrible flashback during this cross when he's going through all these questions with Russell, and all I'm thinking is, why the fuck didn't Alessi ask the same type of questions to Welcher? Because that guy didn't give any explanation, nothing. Let's not forget that. He was not asked, he was not challenged at all. Not about the 8 mile an hour thing, not about how just mechanically a taillight exploding could cause those wounds. I mean, nothing. Like I mean, can you rely on, like, maybe they're sitting there as the defense, they're like, all right, well, I'm not going to ask this guy the questions because we've got ARCA coming up. But man, it's like you have to attack their witnesses if they're just saying some shit that's got no basis in science or engineering. And it just went unchecked. Let's see what we got. Let me go through some comments. Sober, here's to Dr. Marie Russell putting up with Hank's constant bullshit and badgering and inspiring women everywhere. I mean, we all love Dr. Russell. We all love Dr. Russell. You know, like, but you can't pretend that the fact that she testified that there really is no one methodology that that's accepted in the dog bite community, which I've never heard of. You know, because I don't know how that affects a jury. You know, just those words. Well, so no one else out there in the world is doing this? Like, you're the first one to have done this? She's not. I mean, clearly she's looking at the wounds and the pattern of the wounds, and she's taking into consideration this concept that it was done by a taillight, which is what the state is putting forward. And she's rejecting that. She's like, that's not what happened here. Like, I can look at these wounds, and based out of the possibilities of things that could have happened in terms of other extrinsic kind of evidence that I'm aware of. So like Hank asking her about all the other bullshit didn't matter because none of those things mattered. The only two things that would matter to her in her evaluation, at least in terms of what the state and the defense are putting forward as theories, is either a taillight did this or the defense thinks a dog did it. So that's where she's starting from. That's her jump off point. And she is looking at those wounds, and based on 30 years of experience and having seen and having an interest in dog bite wounds and dog scratch wounds, you know, she's reached this conclusion with a reasonable degree of medical certainty. You know, whether or not there's an actual methodology, you know, that's widely accepted. I mean, she had to answer it truthfully, and she said no. Like, there is nothing out there. There's not one treatise out there that I could point to and say, yeah, this is kind of the end all be all. Like, you get those experts on that literally, like, I'll say when I've had an expert that has written the book, I'm like, you literally wrote the book on this. Like, when we were going to call Werner Spitz, who's the, you know, probably the most preeminent when he was alive, preeminent forensic pathologist in the world. I mean, the guy testified, he literally wrote the book on it. He wrote the book that other forensic pathologists use to assist them. You know, so there is no book like that. There is no treatise out there that exists in terms of these types of wounds. But, you know, the bigger point, which I'm sure that Bob's going to get back to, and I talked about this a lot during the first trial. Typically, when you have dog bite wounds, either there's somebody who witnessed it in terms of the attack, or the person the victim is still alive. So you're not having to try to figure out whether or not a dog did it at all. It's very like she kind of answered that question and said, like, I've never been presented with a situation like this wherein I have to try to figure out whether or not a dog was involved because there's no witnesses. You know, like this is a very unusual circumstance. Like if you just think about most of the time when you're talking about dog bite injuries, I think it's pretty rare for an adult to be killed by a dog. It's not to say it doesn't happen, but typically if they are, there's going to be witnesses involved. And or it's in a situation where it's the only thing that could have happened, say somebody in their house and they were attacked by the dog. And you could, it's the only possible explanation. Like here, that's not the case. You've got these injuries on the arm. You've got the state's theory, the Commonwealth's theory that he was hit by a vehicle. So you've got these competing theories, and you've got an expert who's trying to put the pieces together to try to figure out what happened. But what I'm saying is she only has two places to start off from. It's either shattered taillight somehow caused this, or a dog. And that's what she was dealing with. So it's frustrating. It's been a frustrating day for me, like listening to it. And I get why everyone hates Hank. Like I really do. You know, but cross-examination is where you're challenging the witness's testimony. And you know, if it's confrontational by its very definition, that's what cross-examination is. Why it exists. It's literally the confrontation clause of, I mean, that's what it comes from. That clause, it's called the confrontation clause. You know, I mean, you're never going to find for either side. I wish that Alessi would have really confronted Welcher a hell of a lot more than he did about his ridiculous theory of the taillight exploding, causing those injuries. You know, I think that they kind of just decided to lean into ARCA. But I mean, whether or not that's going to end up being a mistake is yet to be determined. Amy's positive pathways. Hank, she has established this. Slimy man. Yeah, you're going all the way back to 846. I like Harry's. I don't even know which particular point you're discussing. If you're still here, throw it in the chat. Meg P, were the taillight pieces tested for blood? I can't remember. I don't think so. I mean, if they were, I mean, that's a good point in terms of like, and that's really in I probably should spend a little time if I can whip through these comments. As predicted, the defense has filed the motion to reconsider allowing Easter to come in. And if you're not familiar with Easter, he is their expert that they were going to have talking about what a proper investigation is supposed to look like. And I kept saying I fully anticipate that they'll file a motion to reconsider. I think they opened the door for him to come in. I don't think that they should be allowed to put anybody on the stand saying that this was a good investigation. Yeah, leaf blowers. It was a real novel, ingenious idea came up with. We're going to use it all the time. Red Solo Cups are great at collecting liquid. like that's got to be rebutted. That has to be rebutted, and she has to allow Easter to come on. I think when they ask those type of questions, I think that completely opened the door to Easter coming back in. And whether or not the taillights whether those were tested for blood. Is anybody aware in chat whether they were or they weren't? I don't think that they were at all. I mean, like, think of it like this. Okay, like typically for blood, you're going to see, you know, like a brownish reddish type stain that, you know, they never say it's blood. They always use that brownish reddish biological material potentially, and they'll swab that. So if they didn't see anything like that on the tail light, they wouldn't have swabbed for it. But, you know, in terms of skin cells, you know, or any other biological material, I am not aware that they did any testing on any of the taillight pieces for that. Let me know in chat if you guys know different. And thank you, Meg. Malo, most hated, Lally versus Brennan. That's a no-brainer. Brennan, no question. No question. Thank you, Malo, for being a member for 15 months. Holly B, thank you. Is this considered badgering the witness? No, that's I answered that during the chat. I mean, we all love Dr. Russell. Such an accomplished woman and sticks by her guns, and she's earnest and honest.
You are unmuted.
But grilling a witness on the stand is not badgering. It's just not. Badgering is when you're yelling at them and not allowing them to finish, and was completely destroying the witness on the stand without giving them the opportunity to even answer the questions.
All right,
them.
so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Sorry. What she means is your rights have been saved, that it's for appeal. That those rights are for appeal. So, like, if had they not made that motion, you know, it's waived. So that's what that means.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh, yes, but not right now. They're on their way. All right. Do you have
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to being done outside the jury. That it should be done like I've had to do with several witnesses in front of the jury.
Okay. If that's what the defense wants. Are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confirm with my. Yeah, okay. I am going to, yes, Your Honor, we are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
You're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is are the lunches here?
Oh God.
Probably not. Okay. Are they still over there?
Why'd they turn the volume down?
Did you start yet, or can you?
If they're downstairs on their way up, I don't want to stop them.
I can do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, but I'll be subject to whatever Your Honor does. Based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's
scheduled for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now. Okay?
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Or- Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard, I disagree with his assessment.
Thank you. Sorry, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had here with the cause where witnesses disregarded it and I was not allowed to pursue questioning. So I do not believe under the standards that's been set in this trial, the proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Leslie?
Thank you, Your Honor. My response is this. I'll give two quick examples. Dr. Welcher, Trooper Ball, Dr. Squirty Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Squirty Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark.
Okay. All right, thank you, Hunter.
All right, so they're going to bring the jury back in. I thought she was going to kick in right to lunch, but so I mean that specific point, like he's not going to be able to get into anything about Welcher's opinion. Like that's what that little win was, because he can't lay the foundation with the witness.
Objection.
What?
Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
Could you guys just say 15 minutes?
The DNA. It's not, right?
It is not. And
Okay.
is there a question?
Yeah.
Yes, it's open. I denied the motion and allowed the line of inquiry.
Yeah, this is getting sticky. This is getting, the whole DNA thing is to me very problematic. I don't understand why she's allowing it in. I mean, what it does is it creates a situation now where the defense is going to have to address it somehow.
Back in session, you may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was.
Oh, that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or?
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over.
Asked and answered.
Right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Tech stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the tech stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it. And I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions. And so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve. Yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it, excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Renew the objection.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So yes, I am aware that there was some swabs taken at some point.
Is that gratuitous answer part of your advocacy
Oh,
or
shut
part
the
of
fuck
your
up. Objection.
medical objective opinion?
Come on.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, and giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes,
In fact, what was found was pig DNA,
that's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog who bit John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes,
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection. Is that a question?
So the objection sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA. Yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly? You know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scotabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
There you go.
You can't tell us one step that went wrong with that DNA process, can you?
Yeah, they didn't swab the
process, no.
wounds.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally,
And
yes.
did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Potentially.
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
Oh, God. Let him ask a question. Like, all she has to do is answer it. I don't care what they found in his sleeve. In my opinion, with a reasonable degree of medical certainty, a taillight did not cause those wounds. It's that simple. Just keep saying that over and over and over again. Like, all this other shit doesn't matter. Those wounds, that pattern of wounds was not caused by a taillight. It's that simple. It's that simple. She doesn't need to get into the weeds in it. Just keep repeating that over and over and over again. Because you know what? The Commonwealth has done nothing in terms of providing any evidence to this jury in opposition of that. Nothing. They presented zero evidence as to how a taillight could have caused those injuries. It's unrebutted. I mean, that's it. It's that simple. Like, I hope she doesn't start to try to explain. Sir, it's this simple. A taillight did not cause those injuries. Not with that pattern of wounds. Not with that pattern of wounds. It didn't happen. Because the rest of this shit just doesn't matter. Just doesn't. She's looking at pattern.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could
Oh my
cause
God.
cuts or abrasions to
Oh my
Mr.
God.
O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
There you go.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance
No,
he moved
neither do you,
when he
Hank.
was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
Do you think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision. I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused
Oh my fucking God.
superficial abrasions on John
Object!
O'Keefe's right arm?
Okay. Do you see that picture they just had up? Here, I'm going to fucking show you. That is not what they found in his fucking sleeve. Like, why aren't they objecting? That is not what they found. They found the biggest piece was like a size of a piece of rice. Why are they allowing this testimony to come in? That is not the type of material that was found in his fucking sleeve. Oh my God, I'm like about to lose my mind.
Do you know how Mr. O'Keefe fell
No.
down? Where his body was found on the side of the road?
Yes.
Fuck.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
Objection to
You know,
fragments.
in reference
like
to that
this.
last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision. I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again.
Oh my
Are you
God.
saying to a reasonable degree of medical certainty that these fragments,
Those aren't the fucking
did not
fragments. Oh my God.
the
Object.
superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Okay.
Okay, I need you to pull up the picture with the microscopic fragments that they found in the sleeve.
For my cupcake drops.
That doesn't help. That adorableness does not help. I'm furious. That was egregious, him having that picture up there saying Pieces like this. Ah. You better fucking right this ship right now.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidences 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards.
Thank you.
Can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back, can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E.
I don't even know what the fuck we were looking at. What was that circle?
With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolf, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolf, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently.
Don't
Mr.
call them
President.
shards. Those are not shards.
Dr. Russell,
Tiny little pieces.
please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic,
Jesus.
1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, and are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that the article was reviewed by other physicians in those respective specialties
So
of
if we
the
could just-
authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
Have you
sorry.
finished?
The specialties of the authors, yes.
We could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification P, 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 and Q, Q, Q.
All right.
And I'll start with P, 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 if I could, please. Thank you, Madam Court Reporter. May I present PPP to it? Thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. Demunich?
Yes,
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
yes,
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Sure. 298. If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting, curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items, if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought
Was
you
the
meant in this
decedent-
article, but yes, there's textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt
Please continue.
or sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I don't want to
keep on
keep
reading.
reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Oh, yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell.
Mhm.
Thank you, Madam Court Reporter. So do those studies, the Munich and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Leslie.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or?
Well, I'd like to
pain?
give you an example of what you used here in this case as the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong. And so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression. But I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips in audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame? Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
What?
Your Honor, may we approach?
He opened the fucking door completely. Like, typically, he couldn't ask her this on his original direct because it's not what she's here for. But once Hank started asking those questions, doors open. The door's open. Period. I mean, when Alessi walks through the door, that means that Hank's going to be able to come on and recross her and ask, okay, well, do you have any training in what you just testified to? I mean, he's going to be able to come after her on it, that it's not her area of expertise. Yeah, I've seen a couple people in the chat be like, wrap it. I kind of feel the same way. I mean, to me, you're getting into the weeds here, and beyond that, it's a dangerous area because it's not Dr. Russell's area of expertise. Frankly, I think he could have sat down as soon as he showed the microscopic or whatever the hell, the teeny little pieces of tail light that anybody with eyeballs can see did not cause those wounds. Like that theory that somehow those things were embedded and or stuck in the sleeve and somehow caused them some kind of friction, rubbing back. Get the fuck out of here, please. It's like no one's buying that. Yeah, God. I have not loved this morning. I have not loved this morning. I did not think it was I mean, I trials like this are tough. There's ebbs and flows, but I think that Alessi just needs to keep this very narrow. He doesn't need to try to over explain everything. I think that the one thing that was very effective was the thing that he handled first, the thing that I was screaming about, that it better be those pictures. And it was, because that's the crux of this, right? Like, that's what matters the most. That's what matters the most. I mean, I just want you to think about, like, if you form an opinion on a case that you're watching, or it's this case or any other case, and you're feeling a certain way about an attorney and their questioning, and if it's usually anger or nerves or anxiety, it should be a little hint to you that lawyer is being somewhat effective in terms of their cross-examination. Like, everything that Hank was asking, frankly, was fair game. I mean, he's got the ability to be able to challenge her opinion. And to do that, you've got to come at them about their opinion. And, like all the things that he brought up. So, I mean, do you guys think it was effective to have her read a couple of learned treatises, like a couple of the articles that are peer-reviewed articles? Do you guys feel like that was effective for the jury? See, I don't. I mean, I don't think it was ineffective, but I don't think it was effective. I think maybe to the broader point of just proving that there's literature out there in general, it was helpful. Well, that's kind of it, Brian. Like, I mean, that's kind of what the point is. It's like you need to make sure that the jury's engaged. You don't want them drifting off. You don't want them not paying attention, because you never know. I mean, you could have a juror just sitting there looking at you and they're thinking about a million other things and not listening to a word that's being said. I mean, you never know what a juror's doing. Yeah, Larisha, I hear what you're saying, but I mean, they were all pointed towards one direction, and that was that, those wounds weren't caused by a dog. So while he was throwing a bunch of shit up there, they were all kind of geared towards that one area. I mean, to me, and unless he handled it, kind of the biggest piece of shit that he was throwing up against the wall was breaking the wounds down one by one. That whole, oh, well, individually, could you say that this was a dog? And she would have to say no. Because again, this is a pattern. This isn't an individual wound. That, like, the questions in and of themselves were improper because we're not talking about an individual. Like, we're not playing this game where we're pretending the rest of the wounds on the arm don't exist. Like, that game doesn't exist. That game's bullshit. So Alessi was able to clear that up. I mean, it's a wound pattern thing. But at the end of the day, you know, I think that what really has to be said and asked by Alessi is, I want to hear her say with, you know, with a reasonable degree of medical certainty that those wounds were not caused by a shattered taillight. And I want to hear her say that that's right, they were not. You know, and then sit the fuck down and let it go from there. Because trying to get into the weeds on every single thing, you know, is just like, she's been on the stand for a long time. You know, and she's doing her best. It's like, it's challenging when you have a witness up there, and as the attorney, you know what you want your witness to say, right? And it's happened a couple of times on this redirect. You know what you want her to say. Like, he definitely wanted her to definitively say, yes, I now can tell, when he was talking about the initial ruler with the circle thing, the little cup that I assume was holding is that where the shards were? I didn't see the shards in that little circular thing. Is that where they were? Because if they were, then they are microscopic, because I didn't see shit in that circle thing. But, you know, he wanted her to clearly say, yes, that's obviously the same ruler. You know, he could have asked the question, would it have been helpful for them to have taken a further shot out so that you could see it was the ruler? You know, but he wanted her to say, yes, I can see that that's the ruler. You know, and there was been a couple other questions where he has that answer in his mind of what he wants her to say, and he can't quite get her there. And she's trying her best to get there. But you can see on her face that she knows that he has an answer that he wants, and she's trying to do her best to give him that answer.
May I have a moment, Your Honor?
Yes.
Thank you. Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his
Let's get some bloop.
Yes.
So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in a reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But
Thank
I would
God.
also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? Lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here, what is the likelihood of there being any fracture to any bone?
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scorbello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scorbello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her for lunch?
All right, jurors, I'm gonna send you out for lunch, okay? We'll see you at 2 o'clock. Yes, come on up.
To the court, please.
Okay. All right. What the hell? All right. Throwing the poll up there. Get a vote in. Vote early, vote often. I picked between Dr. Russell's testimony from the first trial or Lucky. Whoever for Lucky is coming on today. All right, let's see if they're going to handle some business. See what we got going on here. All right, we're live. All right, thus far it is landslide Lucky. So all right. Okay, let's see if I can find Lucky. Lucky. All right, I'm scrolling through here. Let's see. Paul Guarino. Wolf Rensler. Okay. Oh, there's Lucky. Found Lucky. What a sweet guy. What a sweet guy. All right, we're gonna hang in here though, see what's going on. Yeah, I mean, Tehuff, that's Bob's handling the experts for the most part. I mean, we saw Ajax handling a couple of the people from the crime lab, but in terms of experts, Bob's the guy. Bob is the guy. All right, let's see. The poll, it's 80-20 to Lucky, the 157 votes. Come on, why aren't you guys voting? It's like trying to get people to hit the like button. Just pick one. It's either Lucky or Dr. Russell. Let's go. Do it. Do it. All right, bullied a few people to vote. I don't get it. It'll say like 173 and then it'll go down to 168. Maybe that's people changing their votes. All right. Right now it's a landslide for Lucky, but we're going to wait. We're going to wait here and see if anything's going on of interest, of note. So she took lunch right at about noon for me, so 1 o'clock. Yeah, Raul, that was unbelievable. The whole Dever thing was. I felt vindicated that Alan called her Deaver too, because I definitely called her Deaver. She took great offense to being called Deaver. She didn't like it one bit. All right, let's see what's happening.
All right, Chrissy, does that help?
Did she say when you're coming back? An hour?
All right.
All right, so I'm gonna pull Lucky up, and I'm actually gonna get some food because I'm starving. Let's see. Okay. Where did I put it? Okay, here it is. Move it over here. Okay. All right. Okay, you guys are going to get to watch the magic of Lucky. The whole thing. I'm going to do the whole. Remember, he was a defense witness, so we'll do the whole thing because it only lasts. It's about 48 minutes of direct, which was obviously done by the defense, as he was a defense witness, as well as the cross by Lally. All right, you guys ready? Let's
Can you
go.
State your name and spell your last name.
Oh,
Sure, it's Brian Loughran. It's Loughran.
And where are you from,
Mr.
sir?
Loughran, I'm going to ask you to keep your voice up as loud as you can, sir.
She's already freaking poor Lucky out, screaming at him, keep his voice up. I love Lucky. What a guy. What a guy. All right, y'all. So I'll pop back in around like 12:50, 12:55. I'll keep an eye out. I think we got an hour though. Full hour. So all right, let's watch some Lucky.
Sorry.
That's okay.
Put your mouth as close to the mic as you can. Where did you grow up, sir?
Canton, Mass.
Is that where you live?
Yes.
How long have you lived there?
Both 35, 36 years.
And did you go to Canton Public Schools?
Yes.
Now, in the course of living in Canton, were you familiar with the Albert family?
Yes.
Which members of the Albert family were you familiar with?
All of them.
And when you say all of them, can you name the ones that you were familiar with?
I was familiar with Brian,
Brian Albert?
Chris Albert, Brendan Albert, Kevin Albert, and I believe Kathy Albert is the sister, but I'm not 100% sure on her first name.
Okay, and those are the siblings that you had contact with and were familiar with?
Yes.
Did you know some better than others?
Yes.
Whom did you know the best?
Chris Albert.
What is the age difference between you and Chris Albert?
I believe we're the same age.
Did you graduate high school with him?
He went to a different high school, but yes.
Graduated at the same time?
Correct.
And with regard to your familiarity with Chris Albert, can you explain to the jury how you became familiar with him and what your relationship with him has been?
I went to school with him, elementary school. We went to middle school. Then he transferred to a Catholic school. Then later in years, I began to work for Chris for D&E Pizza, delivering pizzas.
Okay. And approximately what ages were you when you were delivering pizzas for D&E Pizza and Chris Albert?
I was 25, 26 years old.
And how many years did you deliver pizzas for him?
Up until I got married, 35.
So several years.
8 years.
8 years, okay. And with regard to your interactions or knowledge of Kevin Albert, can you describe that?
Kevin Albert would be through D&E Pizza if he came in. Through the police department, would see him on details.
All right. And were you friendly with him?
Yes.
With regard to Brian Albert, could you describe your interactions or your relationship with him?
Again, through D&E Pizzas, delivering pizzas to his house. Cordial, polite, would say hello.
All right. So you're friendly with the Albert family?
Correct.
Now, back in January of 2022, where were you working?
I was working for the town of Canton.
In what department?
I was working in the sewer department.
Is that also called the water department?
Yes, water and sewer are combined.
And under what heading is that?
The DPW.
It's under the DPW, the Department of Public Works?
Correct.
Now, back in January of 2022, were you one of the regular snow plowers for the town of Canton?
Yes.
And directing your attention to January 28th of 2022, do you remember that day?
Yes.
What do you remember about that day, the 28th?
It was a potential blizzard. We had been given a start time.
All right. And when you say you had been given a start time, what does that mean?
It means that we're expected to be in our trucks at a certain time on our route.
Okay. And who gives those instructions back in January of 2022?
The supervisor for the Canton DPW.
And who was that at the time?
William Walsh.
Also known as Billy Walsh?
Yes.
Now, when were you called in to do plowing that evening or early morning?
We were told to be in by 2:30
And is that 2:30 a.m. or p.m.?
a.m.
Would that now be on January 29th?
Correct.
What time did you arrive at the DPW that early morning?
About 2:15.
When you got there, what did you need to do in order to go out plowing?
I needed to get into my truck and get that prepared to go out.
All right. And your truck, is there one that's specifically assigned to you when you plow?
Yes.
And does that truck have any particular nickname?
Yes, it's called the Franken truck.
And why is it called the Franken truck?
It is a truck that has a lot of different parts than what it's required. It's not parts that were made for that specific truck.
An older one?
Yes, it was a truck that was very uncomfortable at the beginning to use, so they try to make it as comfortable as possible.
All right. And that particular truck, is it used for anything else other than snow plowing?
Yes, it's used for everyday use.
Okay. Now, so you get to the DPW at 2:15. You say that you get your truck ready. What does it that entail to get your truck ready, and how long does it take?
It takes about 5 minutes. We just basically you need to make sure that it's got enough gas in it, so we're not going to the route and running out of diesel fuel, which is not good. It's just basically going over the truck, making sure you have everything you need for that night.
And do you plow alone or with someone?
By myself.
Now, with regard to the visibility in your snowplow Franken truck, can you describe that for the jury, what you can see, what you can't see?
So the Franken truck has an air ride suspensions, an air ride seat. So the seat is raised so I can see over the hood. Okay. And I can see about 5 feet on either side of the passenger side, driver's side.
And when you say 5 feet, are you talking straight out from the
windshield, straight out?
All right. And what, if any, lighting do you have on Franken truck?
We have marking lights. We have 2 plow lights that are situated at the corners of the trucks, and it's up high. It illuminates very well. It's very well seen.
Okay. And with the extra set of lighting that you just described, how far can you see off to the sides, in front of you, and directly in front of you?
Probably 5 feet on the sides.
Well, so you already testified to that, 5 feet straight out.
Yeah.
But what about the sides going forward?
It's hard to decide to put into words, but I can see a real long distance. That visibility is fine. It is extremely. If you gave me probably 5, 10 feet, 15 feet out, maybe even further.
Okay. And with regard to the lighting, how much light does that give off?
Enormous amounts. It's almost driving with the spotlight.
And with regard to the air ride seats, what action did you take with those that particular night?
I raised it so that the bottom of my knees would hit the steering wheel.
And what, if any, obstructions, I should say, were in front of you that would prevent you from seeing what's in front of you or to the side?
Nothing.
All right. Now, do you have a specific route assigned to you?
Yes, I do.
Could you describe that route? And by the way, that specific route, was that the one that you were assigned on January 29th?
Correct.
Could you describe that for the jury?
Yes, it's a route that consists of Cedar Crest from Kings Road to Chapman Street and everything in between. There are a lot of streets I could name if you would like, but Fairview is one, Spring Lane is one, Cedar Crest, Kings Road. Those are pretty important roads that I would consider major roads on my route.
All right. Now, that particular night, if you got there at 2:15, what time do you think you were on the road by in Franken truck?
I was on Cedar Crest about 2:30, 2:35.
Now, With regard to Cedar Crest, I would like to show you a map if I can. May I approach, Your Honor?
Yes.
I've handed you a document. If you could just review that to yourself and then look up at me when you're done. Do you recognize what's depicted on that?
Yes.
What is it?
It is my plow route and consisting of streets that I plow.
All right. And to be fair, that's a portion of your plow route, right?
Correct.
There are other areas of the city that you plow?
This actually depicts my actual physical route.
Oh, okay, great. And that's a fair and accurate representation of the streets as they existed back in January of 2022?
Yes.
I would offer that, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Okay.
Okay, now, you just testified that you got to Cedar Crest, I believe, you said 2:30 to 2:35 or so?
Correct.
All right, as we look at this exhibit on the screen, are you going from right to left or left to right on Cedar Crest when you first approach Fairview?
Right to left.
Okay, so you're going sort of from the upper right-hand corner of the diagram down Cedar Crest toward Fairview. Is that accurate?
Yes.
Could you take the laser pointer and just confirm that route for the jury? That's, okay. You see that's Fairview Road? Are you able to read that right?
I'm not, to be honest with you. I'm sorry.
Do you still have that map in front of you? Maybe that'll help you, Mr. Wall.
And actually, can I orient it so it's oriented just like that for him? And by the way, I should have asked this, but is it in terms of is it you can't read the writing or you can't really see the outline of the streets?
Both.
Okay. Well, that's not going to help much. Okay. If we can have the lights back on. With the court's permission, can I leave that up on the screen while I ask a few more questions?
Sure, except he said I can't see it.
Right. No, I know, but the jury can. So I think it would be helpful for them. All right. So you're coming down Cedar Crest, and would Fairview be on your left or your right when you first approach it?
When I first approach, it's on my left.
All right. Now, do you take that left at that time?
No, I do not.
Why not?
At the time, I'm pushing snow, and we don't want to block any part of the road with snow, and taking a left would have left a row of snow. So I proceed to the end of Cedar Crest, do a cul-de-sac, and then head back up Cedar Crest.
All right. So there's a cul-de-sac at the end of Cedar Crest.
Correct.
Dead end.
Yes.
And you plow that?
Yes.
All right. So then when you come back up, is Fairview on your right or your left?
It is on my right.
What do you do?
I take that right and continue to plow.
Now, are you familiar with the Albert residence on Fairview Road?
Yes.
How did you become familiar with that?
Growing up in Canton, I knew where they lived.
Can I have exhibit 66 displayed with the court's permission?
Yes.
From where you're seated now, Mr. Loughran, are you able to see what's on the screen?
Yes.
And do you recognize that?
Yes.
What do you recognize that to be?
That is the Albert house, Brian Albert's.
And when you were passing the Albert home on Fairview, the very first time you passed it, would it have been on your right or your left?
It would have been on my right.
What section of the road were you plowing at that point?
The middle of the road.
Why is that?
I start in the middle and I angle right with the plow.
Now, I want to direct your attention to when you were, your truck was essentially perpendicular to the driveway. You see the driveway in Exhibit 66?
Yes, I do.
When you were perpendicular to the driveway, where were your headlights pointed?
In front of me. In front of the truck.
I'm sorry?
In front of the truck.
And what were you able to see of the front lawn of the Albert residence that very first time you passed?
I was able to see the entire front lawn.
And about what time was it that you first passed 34 Fairview Road?
About 2:45.
Now, as you continued along past the driveway, did you continue to have all of those headlights on in front of you?
Yes.
And as you continued along, what were you able to see of that home eventually?
A very large portion, almost to the front steps.
And now, when you're plowing, where is your attention focused, sir?
My attention's focused in front of me and then to the sides.
Why would your attention be focused to the sides?
I am trying to be aware of any side traffic, any pedestrians, and God forbid, any animals.
And when you were passing the Albert residence, as you pass every home, what attention do you pay to the size of the road and the lawns that are adjacent to the road?
I'm, again, making sure that there are no animals, no pedestrians, and making sure no one's coming out of their driveways, not expecting to see me.
And with regard to Exhibit 66, do you see the flagpole there?
Yes.
Is that something you had seen previously?
Yes.
And when you made that first pass by that residence at 2:45 in the morning, sir, with your headlights on, what, if anything, did you see on the front lawn in the area of the flagpole?
I saw nothing.
If there had been a 6'2", 200-pound man lying in the snow there, would you have seen it?
Objection.
Sustained.
Now, once you pass the residence, where do you go?
I go to the end of Fairview.
And what street does that intersect with?
That intersects with Chapman Street.
If we have the previous exhibit put back up with the court's permission. Sure. Okay. Do you still have the exhibit oriented the same way, sir?
Yes, I do.
Where's Chapman Street on the exhibit? Down the bottom, the top, or which?
Down the bottom.
Okay. And when you come to the end of Fairview with Cedar Crest in your rear now, right?
Correct.
Do you take a left or a right on Chapman?
I take a left
All right.
onto
And
Chapman.
once you take that left, what do you do?
I back up and then take a left to go back down Fairview.
Okay. So you're essentially doing almost a three-point turn in the road?
Correct.
All right. So now, do you go back down Fairview at that time?
Yes, I do.
And how far do you go down Fairview?
To the end, to Cedar Crest.
Now, at this point in time, you would also pass the Albert residence, correct?
Correct.
Would it be on your right or your left?
On my left.
Were you looking to the right and the left as you were coming down?
Yes.
How much light did your headlights illuminate of the Albert's front lawn as you were coming down from Chapman Street?
Coming down Chapman, just about the entire front lawn.
And again, with regard to that area around the flagpole, did you see anything on the lawn?
Nothing.
See a body?
No.
All right. Now, after you've done these two passes, sir, where do you go?
I then take a right on the Cedar Crest. I proceed up Spring Lane, come down Spring Lane, and then do the remaining of my route.
How long did it take you before you wound up back at Cedar Crest and Fairview?
About 45 minutes.
So I think you had previously testified you made the first pass around 2:45?
Correct.
So would that put us at about 3:30 when you're about to make the second pass?
Objection.
Sustained, ask it different.
Sure, I'm sorry. What time was it, to your best estimate, in terms of when you would have approached Fairview and Cedar Crest again?
3:15 to 3:30.
All right. Now, when you approach that intersection again, are you approaching it such that Fairview would be on your left or your right this time?
On my left.
Same as last time.
Correct.
What do you do when you approach Cedar Crest? I'm sorry, when you approach Fairview and it's on your left?
At that point, I have an option I can go to the end of Cedar Crest, or I can turn around at a street depending on how much snow I have on Fairview.
And with regard to the decision you made regarding that choice, what decision did you make on January 29th at 3:30?
Went all the way to the end.
Went all the way to the end of Cedar Crest.
Correct.
Same thing you did the first time.
Correct.
And then you come back up.
Correct.
Is Fairview on your right or your left at that time?
It would be on my right.
And did you take that right?
Yes, I did.
What, if anything, unusual did you see at that point?
At that point, I saw a Ford Edge on the side of the road.
Where was it parked on the side of the road?
In front of the Albert's house.
Where in front of the Albert's house?
By the flagpole.
And why was that unusual?
The Alberts never had cars that were parked out front, and it just stuck out as weird.
Now, what were the snow conditions like at that point? This is now, I think you said about 3:15 to 3:30.
It's starting to accumulate a lot quicker than what it was previous.
And what policies does the DPW have regarding cars parked in the street during a blizzard where there's plowing to be done?
We are to notify the supervisor. At that point, he will make a phone call to the police, and depending on if they can have the resident move it, it gets moved. If not, it gets towed.
And with regard to that policy, did you comply with that policy in those early morning hours?
No, I did not,
Why?
because I was being courteous to the Albert family.
Now, once you saw the Ford Edge parked on the side of the road near that flagpole, what did you do?
I had to go around the vehicle and as to not hit the vehicle.
All right, and probably obvious, but as you're approaching the vehicle, was it faced in the same direction that you were traveling?
Yes,
And so you're going around to the left or the right of the vehicle?
left.
And once, as you were approaching that vehicle, were you able to see on the right side of that vehicle the lawn side?
Yes.
Did you see anything on the front lawn at that time?
Objection.
I'll allow it. Did you see anything?
No.
Lights were still on.
Correct.
All right. Now, once you pass the vehicle, did anything attract your attention at all?
No.
All right. Where do you go?
I go up to the end of Fairview and do the same process. Take a left on Chapman and back down Chapman and take a left into Fairview again.
Once you come back down Fairview, do you pass the Albert residence again?
Correct.
Was there that car that you saw?
Correct.
It moved from when you passed it the first time.
No.
Were you able to see the front lawn of the Alberts in front of you as you were coming down Fairview toward Cedar Crest?
Not as much as the first time because the car blocked the view.
All right. Now, after that, how long did it take you before you came back to that area to plow again?
About 3 hours.
Do you recall about what time it was that you wound up back on Fairview?
I don't honestly recall what specific time.
Sure. Approximately, if it was 3:15 to 3:30, that second time, what would be your best estimate of the time when you came back?
I would say if I had to say, it would have been 5:30 up Fairview.
Okay.
And came back down, and then at that point I wasn't able to go further than Carriage Lane.
Okay, and when you say that you went up Fairview and came back down, you initially went from which side of Fairview?
Right side.
What would that be, the right side? I'm sorry. Would it be the Cedar Crest side or the?
It would have been Cedar Crest side.
Coming from Cedar Crest, and then you went up Fairview, came back down?
Came back down. As I'm going up, I am actually seeing first responders. And at that point, as I'm coming back down, the road's blocked at that point.
Okay. And when the road was blocked, what, if any, plowing were you able to do after that on Fairview?
I was able to go as far as Carriage Lane and then turn around.
Okay. And then I imagine it was several hours before you could plow again?
Before I could plow Fairview to the end of Cedar Crest, yes.
All right. Now, I'd like to direct your attention to February 15th of 2022. Were you approached by an investigator who wanted to ask you questions about what you had seen and done on January 29th of 2022?
Yes.
Do you remember his name?
Yes.
What is it?
Paul?
And what was your understanding about whom Paul worked for?
Objection.
Ask it differently.
On February 15th of 2022, were you ever approached by anybody in law enforcement, sir?
No.
So what was your understanding of Paul's job?
Objection.
I'll see Councilor Taiba.
Just a couple questions, Mr. Loughran.
Sure.
At any point in 2022, were you ever approached by any police investigators, sir?
No.
When was the first time that you were approached by the state police in this case? Do you recall?
I don't recall the actual date, but I do know.
Year?
Yes.
What year was that?
2023.
And do you recall the name of the investigator that approached you?
Mike Proctor and Sergeant, and I can't pronounce his name. I don't want to.
If I said Buchanan, would that ring a bell?
Yes, it is.
I have nothing further. Thank you, sir.
Okay. Mr. Lally?
Thank you, Your Honor.
Good morning, sir.
Good morning.
May I approach?
Yes.
Sir, I'm showing you a document that's already been marked in Exhibit 109. Just ask you to look at that and look up whenever you're finished, okay?
Yes.
You recognize that, sir?
Yes, I do.
And what do you recognize that to be?
These are the plow routes for the town of Canton.
And there's different numbers that are associated with different routes and different drivers assigned to those routes. Is that right?
Yes.
And if you look down at number 11, is that your route that you were talking about as far as the sort of portion of Cedar Crest neighborhood that you plow?
Yes.
And that's the route that you were assigned to on January 28th and January 29th of 2022, correct?
Yes.
Now, if I could ask, just as far as there's a certain way that you plow a route. Yeah. Excuse me. There's a certain way that you plow a road, correct?
Correct.
And when you're first plowing the road, you're sort of plowing the middle of the road, correct?
Correct.
And you do it in sort of a fashion that's referred to as ring road right. Is that correct?
Yes.
Can you explain to the jury what that is and sort of why you're plowing a road in that particular fashion when you're first starting to get out there with the plow?
So ring road to the right refers to the snow coming off the plow. It actually leaves a row of snow. We ring road to the right to prevent cars from having to go through the ring road to the left. If you go to the left, you've now put the ring road in the middle of the left-hand lane. So everything's to the right.
So everything's to the right because if there was a vehicle coming the other way, you'd be plowing into that vehicle. Is that correct?
Correct.
And your goal sort of when you're first getting out there to plow the roads is to sort of clear the middle of the roadway first, correct?
Correct.
So that's where your truck is when you first go out and plow the road, is you're sort of in the middle of the road near the double yellow line if there is one on that road?
Correct.
Okay. Now, this truck that you were driving, on that day, how long have you been assigned to that truck for plowing purposes?
I was assigned to that truck for probably 2 years, maybe longer.
Maybe longer. Were you driving that same truck in 2015?
No.
No? Okay, so you were driving a different truck at that point?
Correct.
You remember what kind of truck that was?
It was an F550 utility truck, pickup truck.
Similar in size or shape to the truck that you were driving that day?
No.
Now, You were asked some questions about February 15th, 2022, when you spoke to some investigator on that day, correct?
February 15th?
Yes, 2022. That Paul person you were talking
Yes,
about. Okay. And you met him at a skating rink, is that right?
correct.
And you said in a statement to him at that time that you would have seen a body on the front lawn or the sidewalk, is that right?
Correct.
Now, are you aware that there is no sidewalk on the same side of the street as 34 Fairview Road?
Correct.
Now, you mentioned some familiarity with the Alberts and with the Albert resident. Are there other people on that route that you're familiar with as far as where they live and who they are and all that?
Yes,
And how are you equally familiar with them, more familiar with them, or less familiar with them?
equally.
Equally? Now, familiarity with 34 Fairview Road, does that extend to sort of the lighting around that area?
No,
So do you know that there is actually no street lighting whatsoever in the area of the fire hydrant, the flagpole, or anywhere there for several hundred feet?
correct.
So you do know.
Yeah, I believe so, yes.
And so when you're driving by, you're looking for cars coming out of the driveway, cars coming in the opposite direction, people walking, is that correct?
Correct.
And you're trying to look for those objects so that you make sure that you don't strike them or hit them or anything like that, correct?
Correct.
And on February 15th, 2022, when you had this meeting with Paul, you told him about 3:30 or 4 a.m. Is when you saw this Ford Edge on Cedar Place, correct?
Correct.
Now, in fact, when you first spoke to this individual named Paul, you didn't tell him it was a Ford Edge, correct?
Nope, told him it was a Ford Edge.
You didn't tell him first that it was a small SUV?
Nope, told him it was a Ford Edge.
You remember at any time Paul taking you on the parking lot and showing you different vehicles and asking you if those vehicles matched what vehicle you saw?
No, he wanted to make sure that what I was telling him was accurate. So he showed me what was a Ford Edge, but I had already told him it was a Ford Edge.
So he brought you out to the parking lot at the skating rink that you were meeting at, specifically showed you a Ford Edge and asked you if that was the vehicle.
Correct.
Now, do you know sort of the difference between if you were to see a Ford Edge at nighttime in a snowstorm, the difference between a Ford Edge and a Jeep Cherokee?
Yes,
What's the difference?
the taillights in the back.
What about it?
Ford Edges are more round. The whole back facade is a little bit more round. A Jeep Cherokee are more square.
Now, what color was this SUV that you saw?
I can't tell you that. I am colorblind.
Can you tell, I'm just curious, sir, as far as your color blindness, can you tell whether or not an object is dark or light just by looking at it? Or you can't tell?
I can see things that are light. I can see things that are dark. I can see true colors. I can't see shades of true colors.
And so from what you saw, was this light or dark?
Light.
Now, you told this Paul individual on February 15th that the SUV that you saw was exactly where Mr. O'Keefe's body was found, correct?
Correct.
How do you know where his body was found?
I told him specifically if he was looking at the door, the front door, it was about 3 feet to the left of the door. And
To the left of the door?
looking at the front of the door to the left of the door, pushing it up Fairview.
So if he wrote in his report that you told him that the vehicle was exactly where the body was found, that would not be true?
Objection.
No, I'll allow that.
Could you repeat that question, please?
If he wrote in his report that you told him that the SUV was exactly where the body was found, that would not be true, would it not?
That would be true. The car was to the left of the door, putting it in front of the flagpole.
My question for you, sir, is how do you know where Mr. O'Keefe's body was found? At any point in time, did you see Mr. O'Keefe's body on the front lawn?
No.
So how do you know where Mr. O'Keefe's body was found?
Through police reports, police interviews, stuff that was posted on the media.
So you've seen police reports in the media?
Well, not the police reports, I'm sorry, but what was said on the news.
So what you've heard on the news, not necessarily what you saw or what you know yourself, correct?
Could you repeat that question, please?
You're recounting sort of what you've heard or saw on the news, so this doesn't come from your personal knowledge or anything about where Mr. O'Keefe was, correct?
Correct.
Okay. Now, you also spoke with some other individuals in May of 2023, correct?
Correct.
Now, did you tell those individuals that you actually came in, and when you say came in, you come into sort of the main sort of hub or the shed on Boulevard Street, correct?
Correct. We punch in.
That's where you punch in and you pick up your truck and you sort of do your checkpoint around the truck and then you go out and plow.
Correct.
Now, you were plowing on this street. Was there any other sort of subcontractor or anything else that was working plowing the roads as well?
Yes.
And who was that?
It was by the yard landscaping.
And so they assist as far as the plow route is concerned, and they go around and they plow things on the same route that you were describing, correct?
Correct.
Now, these other people that you talked to in May of 2023, did you tell them at that time that you actually came in around 11:30 p.m. to 12 a.m.?
I don't remember that.
You don't remember that, or you didn't tell them?
I don't remember that.
So that would be a significant difference, 11:30 p.m. to 12 a.m. from 2:15 a.m. and 2:30 a.m., correct?
Correct.
Now, you also indicated to them at that time that you went past Fairview at approximately 12 a.m. and 2 a.m., correct?
I never did 12, but it was definitely 2:30,
So if they
2:40,
wrote that in a report, that
2:35.
would be inaccurate as well, correct?
Sustained, and only one person can talk at a time.
I apologize. I'm sorry, sir. Please continue and finish your answer.
I didn't hear the question.
Okay. Well, let me ask it again. So as far as if that was contained within a report regarding that conversation in May of 2023, that you went past Fairview Road or went down Fairview Road at 12 a.m. and 2 a.m., that would not be accurate, correct? Objection.
Sustained, ask it differently.
Did you go down Fairview Road at 12 a.m. and 2 a.m.?
No.
If that were contained in a report of your conversation you had in May of 2023, would that be accurate? Objection.
Sustained, ask it differently, Mr. Loughran.
Now, as far as that conversation that you had in May of 2023, did you tell those individuals that you saw the vehicle around 1:30 or 2 in the morning?
Again, I don't remember ever saying that.
Is that accurate as far as whether or not you told them that?
Again, I don't remember saying that.
Did you see a vehicle around 1:30, 2 o'clock in the morning?
I wasn't on the road at 1:30 or 2 o'clock in the morning.
Correct. Now, do you also recall telling those individuals that Fairview Road was blocked off by cruisers at about 3 or 3:30 in the morning?
Again, that would have been incorrect.
Do you recall saying that in May of 2023?
I do not.
May I approach, Your Honor?
Yes.
Sir, I'm going to ask you to read, showing you a document. I'm going to ask you to read this paragraph, and this paragraph to yourself, okay? And then whenever you're done, just please look, right? Are you finished, sir?
Yes.
May I approach this retrieval?
Yes.
Mr. Loughran, after having reviewed that, as your memory refreshed, as to that conversation you had in May of 2023,
No, it does not.
do you still, after reading that, don't recall telling anybody in May of 2023 that you came in around 11:30 p.m., 12 a.m. on the 28th, 29th?
I never came in at 11:30, 12:30 at night. It was 2:30 calling.
You don't recall indicating to anyone in May of 2023 that you went past Fairview at 12 a.m. and 2 a.m.?
Correct. Never did.
And you don't recall telling anyone that you saw the car around 1:30 or 2 a.m.? Is that correct?
Correct.
And you don't recall telling anybody that the part of Fairview containing 34 Fairview was blocked off at 3 or 3:30 a.m., correct?
Correct.
Now, if the part of Fairview that you were talking about, you didn't say that in May of 2023, because at 3 or 3:30, the roadway wasn't blocked off, correct?
Correct.
It was blocked off sometime around 6 a.m., correct?
Correct.
And so if you had said that the roadway was blocked off at 3 or 3:30 in the morning, and it was actually 6, then when you saw the vehicle would have been off a little bit as well, correct?
Objection.
Sustained.
Seeing the car at 1:32 in the morning, with the road being blocked off at 3 or 3:30 in the morning, if the road's blocked off at 6 a.m., then that actually would have been, you saw a car sometime around 5 a.m., correct?
Objection.
Sustained.
Sure you didn't see a black Lexus SUV in front of the house at 34 Fairview Road around 5 a.m.?
No.
Now, you also were asked some questions and you spoke to some troopers in August of 2023, correct?
Correct.
And County Canton, they have a parking ban in Canton, is that correct?
Correct.
That goes from November until April?
Correct.
Now, part of your plow route is a road called Tippy Cart, correct?
Correct.
Where is Tippy Cart in relation to Fairview?
It is on top of it's on the right side of Cedar Crest. It would put it 2 streets before Fairview.
And at some point, when you were plowing on Tippy Cart that night, you actually hit a basketball hoop, is that right?
Yes.
And did you call that in?
Yes.
And as a result of that, what happened with the basketball hoop after that?
Nothing. The point was to make sure I was covered, basically. That's why I notified my supervisor that I hit the basketball hoop.
And about what time was that you hit the basketball hoop?
I don't recall.
Is it closer to when you started, closer to when you ended?
I don't recall. I don't recall what time.
So you don't recall anything specific about that time, correct?
No, just that I know I hit the basketball net.
And obviously, I'm not trying to put words in your mouth or anything, sir, but you didn't intentionally hit the basketball hoop, correct?
Correct.
So you hit it because you didn't see it, correct?
No, I was attempting to avoid the net by going around it, and the machine had a different size body than what it originally had, and I underestimated when I was going around that I need to be wider.
So you misjudged the distance, is that fair to say?
Yes.
May we approach, Your Honor?
Okay.
Now, sir, at some point prior to coming in here and testifying today, have you met with Mr. United?
Yes.
How many times?
Twice.
And when were those times?
Tuesday and Saturday.
Tuesday and Saturday, when, sir?
Tuesday of last week, Saturday of last week.
And this Paul person that you spoke of before, was that person present there as well?
Yes.
And did you make note of Paul writing anything down, or Mr. United writing anything down while you were talking to them?
No.
And as far as you're aware, there's no reports that were generated from any of those conversations or any of those meetings, is that correct?
Correct.
So, sir, I'm correct if I say that you're sure about every time that you went down Fairview Road and everything that you saw going down Fairview Road, but you're completely unaware of the time that you ran into and struck a basketball hoop that night, is that correct?
Objection.
Sustained. You can ask it differently.
You're sure about all the times that you went down Fairview Road?
Yes.
And you have no idea what time that you went on Tippy Cart and you struck the basketball hoop, is that right?
If you ask me to guess, I can guess for you.
I'm not asking you to guess, sir. I'm asking you not to know.
I don't recall exactly what time I hit that net.
Nothing further.
Right. Anything, Mr. United?
There's just one question I want to make sure that we understand what's going on.
So no statements, right? Just ask a question.
I always do that. I apologize, Your
Okay.
Honor. You were asked a question by Mr. Lally. Are you sure you didn't see a black Lexus at around 5 a.m. in front of Fairview? And your answer was no. And my question to you is, does that mean that you're not sure if you saw one or that you didn't see it?
Objection.
I'll allow that.
I did not see a Lexus at 5 a.m.
At any point that night while you were plowing,
No,
you ever see a black Lexus in front of 34 Fairview?
no.
Thank you, sir.
Very briefly, based on your timeline, were you on Fairview Road at 5 a.m.?
Yes.
How so, sir?
It was about 3 hours after the last time I went on it. So it put me, I was last on it at about 4:15, about 5:30.
You were on the road about 2:45, and you said it took you about 45 minutes to sort of do the loop and come back, correct?
Correct.
And from the time that you were on there, including the time that it took you to plow and the time that it took you to do all of those things along the route, you're coming back to Fairview Road at 45 minutes later, or it took you 45 minutes to do the route?
It was about 45 minutes.
And so from there, 45 minutes, from what time are we talking that you were first there? Is that about 2:45 or so?
About 3:30. With some,
About 3:30. Okay,
yeah.
so about 3 hours after that would then be about 6:30, correct?
It was about, I mean, I know I went up there and saw the first responders coming down. And when
What I'm asking is, you would testify that you may or you were on Fairview Road around 5 a.m. If you're not returning for 3 hours later, and that's about 6:30 from 3:30, correct?
Correct.
So then you were not on Fairview Road at 5 a.m., correct?
I was. The time that it took me to do what I needed to do put me there about 5. So when I'm coming down Cedar Crest from doing my route, I am constantly looking at Fairview to make sure that it's considered a main road. So we need to take that as a priority. So if it's a lot of snow on that road, I am going to go turn around and do the road so that the road is available. So first responders have access to that road.
So what I'm saying is you testified, your timeline, that you came down there around 6:30 in the morning, correct?
My timeline was 5:30.
The 3 hours
5:30?
after 3:30.
It was 45 minutes.
No, 45 minutes was from 2:45 to get you to 3:30. Then 3 hours later is 6:30,
It was
correct?
It was about 45 minutes because I didn't get a lot of time. At that time, the snow was coming down at a significant rate, and I needed to make sure Fairview was kept clear. So I come down and I check. So I have the streets are all around Fairview. They're 5-10 minutes around Fairview. So the furthest street from Fairview is Kings Road.
So my question is, are you talking about coming down Fairview, or are you talking about being on another road and looking at Fairview?
Coming down Cedar Crest, looking at Fairview.
Despite that timeline that you gave earlier.
I am always looking at that street.
Nothing.
All right, Mr. Loughran, you are all set, sir.
Thank you.
I'm going to move it as Dr. Lucky Loughran to join us.
Okay. All right, whenever you're ready, Mr. Jackson.
Thank you, Elder. Dr. Russell, could you please, in a loud, clear voice, state your name and spell your last name for us?
Hi, Dr. Marie Russell, Russell.
Doctor, what do you do for a living?
I'm emergency room forensic pathologist, just recently retired.
And prior to retirement, what was your position?
The immediate position before retirement was chief medical executive at for the state of California at the Corcoran State Prison.
So, Dr. Russell, I'm going to ask you to keep your voice up, okay?
Yes.
Right.
Thank you.
Thank you.
There's a couple of air conditioners in here. Just keep your voice as loud as possible. What is, in fact, an emergency physician?
An emergency physician is a medical specialist who has completed a residency, internship residency, residency in the field of emergency medicine, which is a field which involves taking care of patients that are sick or injured and go to the emergency room.
Can you tell us what your education, starting with your education, training, and background is that qualifies you as an emergency physician? Starting with your education all the way back to college.
Okay. Well, I have completed at least 16 years of formal education beyond high school, which includes college, and then 4 years of medical school, then 4 years of emergency medicine residency and internship, and then 4 years of pathology residency, which includes 2 years of anatomic and 2 years of forensic pathology. And then I treated, I've taken a bunch of other courses and attended seminars.
Let's start with your college. Where'd you go to college? Where'd you start?
Okay. MIT. I did my first year at MIT where I took my pre-med courses.
And then what happened after that? By the way, about what year was that?
Oh, that was in 1972 to 73.
Where did you go after MIT?
So what happened? I was interested in becoming a doctor, and so I took the pre-med courses, and then subsequent to that first year, I learned that my mother had metastatic breast cancer, and so I decided to go home to New York to be with her. After that, she subsequently passed away, and I returned to Massachusetts and decided to take advantage of the time off from school to investigate my interest in law enforcement. And I subsequently became a police officer here in Massachusetts.
So following MIT, did you go to a police academy?
I did.
Which police academy did you go to?
I went to the Boston Police Academy.
And did you end up becoming a sworn officer?
Yes.
For how long?
I did it for 7 years full time.
And what department did you work for?
I worked for the City of Malden Police Department.
What years was that, if you could give me a range?
From 1977 to 1984.
During the time that you were a Malden police officer, did you also go to school and continue your formal education?
I did.
Describe that for us, please.
Well, I took specialized courses through the Massachusetts Criminal Justice Training Council.
Objection, move to strike.
All right, so I'm going to strike that. Jurors, disregard that.
Let me ask you this way. I don't want to get into the specifics.
Okay.
While you were a police officer, did you also take formal education to further your medical training?
You're welcome.
Put us back in session. You may be seated.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities, and to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay. Brennan?
All right.
I inquire about scope.
See you type on.
All right, so we kept it brief there. Good. And it sounds like Hank's asking about scope of a recross. So everybody had a good lunch. I had a good lunch. It's pretty good. I was listening to Lucky in the background. What a sweet guy, huh? They get any sweeter than Lucky? It's colorblind. What did Aiden say about Colothecus? Is that how you say that guy's name? Colothecus. Let me pull it up. See what he says. Okay. According to Aiden, sources are reporting to me that Karina Colothecus Kolakithis. Is that how you pronounce it? Kolakithis. A witness for the Commonwealth last trial will testify with a lawyer present that Jennifer McCabe told her that there was ring camera footage of John O'Keefe being hit by in a car, that there was ring footage of John O'Keefe being hit by a car in an attempt to convince her to turn against Karen. This is completely in line with the McCabe's manipulative behavior towards many other witnesses in the days after O'Keefe's death. WBZ also reported this lie on February 1st, the day they were at D&E Pizza, and Matt McCabe texted in a group chat that Chris Albert should, quote, tell them the guy never came in the house. Interesting. Yeah, I could not remember. So were both of the, but like it was the husband and wife, right? They were the two that were at the waterfall that didn't come to the after party. That's who they are. In Greek, her name actually means a zucchini. Zucchini. Are they trying to usurp the Italian language? The Greeks? Is that what's happening? A zucchini. I saw a question in chat of whether or not I thought that Cannoni ruled the right way on the motion for a mistrial. I think there's a valid argument there. I think that it's a powerful appellate issue, potentially, God forbid, because I think it did get into areas that were facts not in evidence, and it left a very distinct, or it can leave a very distinct impression with the jury. I think that they dealt with it fine. Like, I don't think that like at the end of the day, like I don't think anything's turning for the jury on any of that anyway. I think the biggest takeaway from Dr. Russell in comparison to Welcher, if you're a juror, is that whether they believe every single thing that's coming out of her mouth, or they're taking with a reasonable degree of medical certainty, with all the weight that it can come with, is really not that big of a deal for the defense. Because when you compare to what Welcher put forward in terms of a theory on how the injuries occurred, there is none. So you're comparing at least somebody who, for the side that has no burden, at least opining on what she believed caused the injuries, compared to somebody who didn't give any kind of explanation as to what the injuries were, how they were caused. So, I mean, in that sense, it's a win because it's reasonable doubt.
May I?
Yes.
What? What do you mean? No. The burden does not shift to the defense. Absolutely not.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is.
All right, so this is asked and answered. However, he's allowed to bring it up because Alessi brought it up in redirect. So that was the whole article reading thing that you guys seem to like. So now here's here's how he's responding to her reading the articles.
Is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question. So we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Can we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. The way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see 1 or 2 things that show up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity. I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone, on that wound.
Okay, there are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alisi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the, no, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Lessie?
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do that.
Do you see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor. So in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why I'm pressing you on these issues. Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event?
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr. Brennan.
Is that true?
There was no collision, you fuckwad.
I have no details about the collision.
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have
What
any
the fuck is he
details
talking
that you
about?
know of other than what was told to you.
Oh, please, thank you.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise. It depends on the location. It depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard in the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature. And gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
Objection.
I have no idea.
Oh, Jesus Christ. Are you serious?
When you came to your conclusion,
What a scumbag.
considering what you see in this picture, and Attorney Alisi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor.
Sustained.
Finally, Dr. Russell, you said during your differential diagnosis, you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes the report in terms of physicians and what their possible experiences are. Do they work in a medical examiner's office in Alaska or Hawaii or big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Yes. Thank you.
Where's the road
Dr.
rash
Russell, there were
coming from?
questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, is you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for, and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of Attorney Brennan asked you, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those is, and if there was material or textiles or fabric that were in between the bite and the skin. And there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little bit.
Yep. Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw it.
Commentary, I'd like to be heard.
Why don't you bring the reports over? Okay.
All right, what did I miss? Is this sidebar? Sidebarring? All right, hold on. I want to see it. Cameron was screeching, so I had to see what was going on.
Russell, what I would like to.
All right, so he's approaching with Dr. Walsh's report, I think, right?
Dr. Russell, what I would like to do is to give the jury a fair.
Objection.
I'll withdraw it.
Commentary, I'd like to be heard.
Why don't you bring the reports over? Okay.
Okay. He'd like to be heard. Who gives a shit if he wants to be heard? David's like, hey, don't forget this. Tell her this. Remind her about her ruling. See, if I remember correctly, Walsh was a doctor that they were trying to keep out. And I think ultimately the way that she ruled was that he could come in on rebuttal if something was raised. something in particular was raised. That's what I remember about Walsh. But don't quote me on it. Yeah, I mean, I hear you, but you also don't want the Commonwealth having the last bite at the apple during the defense's case in chief. It's like you don't want them being the last ones to get statements in and testimony in that it's coming from the Commonwealth. So, you know. But to your point, I hope Alisi doesn't drag this out. I'm ready for Lucky. I'd like to see Lucky. That would be good. Oh no, what is this? What is this shit now? Why are we going up to the fan? The fan is like when they take the jury out. I hope that's not the case. All right. I think I have very little blooping. Did I call him Alisi again? Jesus. All right, we're up. I'm starting to feel it like it's Hank's incessant babbling is infesting my brain, clearly. I'm going to start saying usurping, the lore. Not going to be able to say words right. My favorite part of the day was when Hank was trying to say sequestration. That was awesome. It's hilarious. He couldn't get it out. Yeah, this, like, right. This is, so Walsh, you should not be allowed to match up Chloe with bites on John O'Keefe. That is proven junk science. Verdicts overturned. Yep. Yeah, bite mark analysis is depending on your jurisdiction, but it's frowned upon. It's frowned upon, for certain. Yeah, but I have to say, you know, the biggest takeaway, which should be argued in summation, is that, and again, somebody, I forget who it was, said something about there's no burden on the defense at all. Zero burden. They didn't have to put on a defense. They literally didn't have to call a witness. There's zero burden on the defense. But in terms of reasonable doubt, you know, that's what Dr. Russell's all about for the defense. She doesn't have to prove that it was a dog bite. She just has to get the jury to think, well, it could have been a dog bite. And then when you balance that against Welsh just saying shit,
Yes.
no evidence backing him up to support his contentions, I mean, Russell should win.
Yes.
Thank you. Dr. Russell, I am re-handing you this letter with from Dr. Walsh. And what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
I'm going to have this marked for identification.
Thank
Okay.
Since possible, no additions and photographs are. Tell me if I do it correctly. I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances circumstances or events surrounding the death, the absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
I want to hear that again.
Next witness. Thank you.
Just how much of the evidence you give to the court and jury in the case down here, and true the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Maybe see.
Good afternoon. All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros.
And where do you currently work?
The town of Dighton, Dighton Police Department,
How long have you worked for the Dighton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I'm a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dayton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual.
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dayton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger.
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barrows, I don't want the address, the cameras are rolling. Did you respond specifically to a residence in the city of Dayton?
Yes.
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dayton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon, he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dayton to retrieve a vehicle that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Did you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault.
Do you think he resembles Popeye?
Let's start
Or
that
Peter
just a little bit
Beerface
slower.
Man?
Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever.
None.
Same with Trooper Proctor.
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes. Once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works.
The whole works.
Did you ever go inside the house?
Briefly,
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there. And I also went in to ask how we're going to get the truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between, longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged. The taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
Boom!
What's different about this photo, sir?
Case over.
That taillight is completely smashed out.
Case over. Can we go home now?
Does it appear that there are
That's rust.
additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence? Objection.
Sustained. Ask it differently, Mr. Johnson.
Of course. Describe specifically, other than the fact that
This guy destroys everything. It destroys the entire theory. This destroys the concept that the taillight exploded when it hit John O'Keefe and caused all those. It's over. I mean, I guess if they want to call art, it's over. This ends it. This guy, he's got no dog in the hunt, no horse in the race. He's got nothing. He's not connected with those scumbags in Canton.
This guy just came in, saw the damn tail light, told the damn truth. I would have started with him, frankly, but he's real nice after Dr. Russell. Isn't he? If one piece is missing, it completely destroys their entire theory of how those arm injuries occurred. Completely. It's destroyed. It's over. It's over.
It's different. Describe in detail. Just
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there.
Dude.
Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen? Like, for instance, the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot on the video?
I do.
Describe what you see.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you. Mr. Brennan.
Thank you.
Man, devastating. Come on, try to make him out to
Good
be a
afternoon,
liar.
sir.
Good afternoon.
Asshole. Can't wait
Have
to
we
see
met
this.
before?
We have not.
Do you still work in Dayton?
I do.
At the time you went to the lead residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene
Yes.
because it's your jurisdiction.
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it.
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house,
Yes.
and then they came out.
They came out much later.
And that vehicle was towed.
Correct.
At no time from when you got there until you left, did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dayton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no
That's rich.
limitation on what
That's
you could have
rich.
written in your report regarding the damage, was there?
No,
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at that moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you? In 24,
what?
When you qualified your answer, was it considering all of those different factors that had passed in between that time?
Damn it.
Can you rephrase that?
Yes. When you decided to qualify your answer and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel and speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
On TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end?
The
Good looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the vehicle in the Sally Port, or the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember previously.
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last?
Wasn't asked. Hank.
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged. It was cracked, and there was a piece missing, but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Can I approach?
Yes.
Hank's setting them up. There's got to be some difference in testimony.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right? Yes.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified. Objection.
I'm going to allow that.
And as you take a look at that, could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dayton on January 29, 2022?
Go to chair.
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you.
All right, here's the whole problem with that. Hank asked that stupid fucking question. You're sure about what you just said about comparing it with the picture at the last trial as you were about what you saw that morning or that afternoon in the driveway at Titan? Like there's the problem. Like Hank is obviously trying to show his memory ain't what it used to be, but it's apples and oranges. Like what he testified to, it's not the same thing as something he visibly saw. This isn't a memory game, but it's an effective technique. Remember, Hank is used to crossing cops. He's usually a defense attorney.
So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why the academy, they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade, right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath, you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah, correct.
And you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about? Objection.
I'm going to allow it.
Over here. What did you talk about? Excuse me.
All right, this is a perfect example. So now he's going to start implying that the defense planted this shit in his head. But this is a perfect example of when attorneys are prepping their witnesses, don't fucking guess. If you don't know, say, I don't recall. Say, I don't, there is no shame in that. Barrow should have said, I don't remember. I don't remember. It was, he asked me a million questions. I don't know. I couldn't tell you. And then Hank's not getting that point there. He's not able to put his memory as to the taillight and the condition that he saw it in question. You have to prep your witnesses. Never guess on an answer. This is a court of law. Shit sticks. You have to ask them. If they're asked a question that they don't know the answer to, do not answer it. Do not guess. Do not guess your answers. But Jackson he'll rehabilitate him. Don't worry.
Okay.
Over here.
All right, so they're taking off.
Could have. Who would they need to send a court summons to, what my schedule was like. Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about?
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay?
Over here.
Over here. Oh, God, he's such a dickbag. Larisha, that's not what's at issue. It's not what he said about it being cracked. What they were talking about was whether or not he was shown the picture from the Sally port with the whole taillight missing, with the entire taillight housing gone. That's what they're talking about. They're not talking about the words. They're talking about, did he remember seeing that photograph at the last trial and then describing it? And that didn't happen. So that's what they're talking about. But Jackson's going to be able to rehabilitate. It just goes from like grand slam, knocked it out of the park testimony to now they're like, Hank did a very effective job catching him up on something that he did not have a firm recollection of, that he should not have answered in the affirmative. He said, I don't recall. If you want to show me the testimony, I'll look at it. I don't remember. Instead, he answered it. Like Barrows doesn't look nervous to me. He looks pissed off that Hank caught him, not remembering that, which now he's using to, as I said, to cast shade on his memory from the day of when he saw the taillight. Jackson's going to ask him flat out, your memory as to what you saw that day is it crystal clear as you sit here right now? Yes, it is. I mean, he'll handle it. Still, perfect.
You told us
world.
there was some background about being subpoenaed and time. Subsequently, what did you talk about with the attorneys when you met them at their hotel conference?
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June, early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably? Or do you think you met them this year?
This year.
You know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV and.
Was it shown to you during your conference room meeting at the hotel?
It was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations in Dayton on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory?
Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay.
Yeah. All right. So let me address Larisha here. Larisha had said recently, Bob, can AJ play trial one? No, it can't. This officer said cracked, not broken. There's no question about that. Like, he definitely said it was cracked, not broken in the first trial. What Hank is doing is putting his memory into question. He got him pinned down on a question about the last trial when he testified at the last trial that he misremembered. He should never have given that answer. Does that in any way, shape, or form really affect his memory of what he saw that morning, that afternoon? Indicting? No, it doesn't. But, I mean, Jack's going to have to address it.
You've seen quite a bit of information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
Well, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dayton. If we could have the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Before you proceed, Ms. Gunn, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look compared to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. Please play this, please. Turn the sound down. Thank you. Stop, please. Do you see that white part of the back rear right taillight?
Objection.
I'm going to allow it.
You see that? Sir?
Can you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop. Can you bring it back, Stop. Back more. Open, right there. Zoom, please. You see, sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day.
Yes,
And when you got to the driveway, it had not been shoveled or plowed.
correct.
There was quite a bit of snow accumulating and ongoing.
Yes,
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes,
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow that was, there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part
I can.
missing? Yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton. Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear tail light and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay, lights on, please, Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain this to the form, Mr. Jackson, is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dayton, correct? Being called out to Dayton to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that?
Mhm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dayton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sallyport in Canton PD? I'm sorry, in Canton, in the Sallyport at the police station
I wasn't.
at 5:30 p.m.?
Sistine.
At any point, did you ever go to the Sallyport at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sallyport?
Objection. Sistine.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
The form, Mr. Jackson.
Of course. What would you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection. So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Yes. Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Do you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
Okay, that's all.
You would agree that your memory has changed since last time you
Ugh.
testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set.
Why is he getting the last fucking word? Oh my God.
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witnesses.
So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day. We'll finish by 1. Okay? Thank you.
All rise to the court, please. Those who don't follow me.
God, what an infuriating day. No, I saw your questions, Larisha. I'm gonna get to them. I was waiting for that to be over. All right, so they're done for the day. Larisha, in terms of this question, Bob Alley said the other day that Hank is not supposed to get up after the defense redirect. Is that true? Yeah, it's typically true. I mean, are there situations where they can get a recross? Yes, but I've never seen it where
Please be seated.
there's not a redirect.
So there have been some motions, I think, piling up.
Case in chief, it is.
2 I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time. I just don't know what you're talking about. Sure.
All right, so yeah, like I don't understand what's going on with that. So if it's your case in chief, you direct, there's a cross, and then typically there's a redirect. Rare occasions does the judge allow for, because it's a judge's discretion. The judge will allow for a recross, but if a recross has been allowed, typically they allow the party whose case in chief it is a last redirect, so they get the last word. Like that last thing there frustrated the fuck out of me. Like why Hank was getting the last word in. So that's not normal. It's not normal. I mean, in terms of whether or not there's going to be recross or redirect is entirely up to the judge. But if Jackson would have stood up and said, I have a question based on what he just asked, then she would have had to have allowed him to go up to do it. So as far as, look, I think Alan did a good job rehabilitating, and the rehabilitation is only as to the issue of his memory. So Jackson did a nice job in trying to kind of show the differences in things in terms of importance, when things might be remembered and when they might not, the minutia details of a trial. You're not going to remember it all. Like I just wish that he'd been prepped and said, look, if you can't remember an answer, please don't guess, because that puts him in that position he was in, and what you were seeing from Barros was like, not like, ooh, I got caught in a lie. It was like, ooh, I misstated that. I was wrong about that. And I was acting like I was sure about it. So that was him in his own mind, like, fuck, like you got me on that one. It wasn't about lying. It's not about lying. It's all about memory. And Hank did an effective job with it. I mean, hey, like, y'all need to know, if you haven't gotten it by this point, Hank is going to cross the fuck out of everybody. The guy's a defense attorney by trade. That's where we live. It's in cross-examination. It's a whole different thing. Like that, like his crosses are going to be brutal. And he's used to cross-examining cops. That's what we do. That's what defense attorneys do. Prosecutors direct cops. Defense attorneys cross them. That's a perfect example of why the defense isn't eager to put Proctor up. Because Hank's going to get to cross-examine him. And that little cross-examination of Barros there as to a completely different issue, but was effective, should be a warning sign as to why the defense is thinking long and hard about whether or not they're going to call Proctor to the stand. Because Hank will do that same shit. I mean, you essentially get to testify when you're cross-examining. You can ask the incredibly leading questions that you're just basically telling the story and just having them plug in a yes or no answer. So his testimony is still devastating. I believe what the guy saw. I think the jury believed what he saw. You know, because Hank tripped him up on the fucking trial bullshit. You know, it just created unneeded issues that didn't have to exist. Had he just said, I don't recall, that's fair. Like, who's sweating somebody from not remembering what they saw during a trial a year ago? Like, no one's sweating you on that shit. So instead, we had 15 minutes of Hank saying, well, see, you were pretty sure, you were absolutely certain about what you testified to in relation to that picture. You were certain about it. You know, I mean, it was just an effective way to put Barros's memory into question, which it shouldn't be. So all of us in this chat are far too biased to think of this, to look at this objectively. Like, I'll just tell you that, guys, flat out. Like we're all rooting for somebody here. Polygraph, can you ask leading questions on redirect? No, you're not supposed to. But the judge has been letting a lot of leading going on from both sides during this entire trial. Let me see where I was at. Man, it's been a frustrating day. Ugh. Ugh. I mean, it's got to be given the weight that it deserves in terms of, as far as I'm concerned, that there's one takeaway from Dr. Russell, and it's in stark contrast with the Commonwealth provided through their witness Welcher in terms of how those injuries were sustained, and that was nothing, zero. They gave no explanation whatsoever. And Russell did. And again, the defense does not have to prove anything. This isn't a trial about whether or not John O'Keefe was bit by Chloe. That's not the issue. All they have to do is put that out there as a distinct possibility, and that creates reasonable doubt. That's how this thing works. Defense doesn't have to prove anything. They just have to put it out there. They had a highly qualified expert who testified, in her estimation, the reasonable degree of medical certainty that those were dog bites and scratches, period, end of conversation. You know, and Hank did what any defense attorney's going to do. Even though he's the prosecutor, believe me, he's a defense attorney first and foremost. He's been doing it too long. The shit just sticks with you. And then as far as Barros goes, you know, where that's going to come and bite Hank, like Hank decided to shoot his load on Barros because he understood how damaging that testimony was. Because if you don't think that all those questions about report writing, about taking pictures, Jackson got into a little, if you don't think that's going to come around and bite him in the ass, it is. Because none of those assholes from MSP or Canton did any of that. And that's who matters. They were the investigating agencies, not Dighton. So he sold his soul to the devil to try to stomp that fire out that was Barrows by asking him, oh, when you write a report, you want to put all the details of what you saw in there. Well, what about Buchanan's report? What about Proctor's report? What about them not taking pictures? They're the investigating agency. You see where I'm going with that? That's going to backfire on him. But he used it there because he needed to, because that's how big Barrows was. But that's going to come back. It's going to bite him in the ass. Mark my words. Mark my words. All right, let's see what else we got. Let me see. Shauna, if you're still in here, I did get your Venmo. Thank you very much. I appreciate that. All right, so I want to get to some stuff that we didn't get to. Yeah, we didn't get much alley today. Yeah, the wedding's coming, y'all. All the prep work's coming. The hair, getting the nails did, eyelashes. It's all happening. It's all happening. I fear we've pretty much lost her for the rest of the week, but we'll see. We'll see how it goes. Just Jim, and thank you, Sarah, as always. I know we're going to be back. Okay, but Alessi and Yannetti have left too much on the table, too many missed opportunities. If I'm AJ question, nah, can't do that. It's too much work for one lawyer, Just Jim. That's why you need a team on a case like this. You just can't, you can't put that all on one lawyer. And look, there's no such thing as a perfect trial. There just isn't. There's always going to be missed questions. There's always going to be missed opportunities, always. For both sides. It's just how trials are. It's not robots in there. You know, it's human beings. I mean, they're like, I can't remember a trial that we didn't walk out of the courthouse on a given day after a long day of trial and multiple witnesses up there, you know, where you're beating yourself up like, God damn it, I should have asked this. You know, I mean, it's just, it happens every single time. You know, because like these aren't scripted events. This isn't, we're not watching a movie. It's all real life. You know, I mean, you should always have a very good idea of what the answer is going to be from a witness, especially on cross. But you can't know, can't anticipate everything. Defense doesn't know what Hank's asking, you know. So, I mean, for the most part, I mean, like, and don't get me wrong, today was a win for the defense overall. I wouldn't call it the home run it could have been. Like the Barrows thing would have been a home run had he just said, I don't recall, about Hank's entire line of questioning about the trial last year. And that he was certain. I'm certain that I saw that picture. And I'm certain that I answered the question in response to that picture. You know, it's like, it's an effective tool to show faulty memory. As to that, does that mean that his memory as to what the taillight looked like when he saw it is in question? No, it doesn't. But how much sexier is that testimony without that 15-minute portion of his memory being faulty in it? You know, if you pull that out, it's devastating. Still devastating. But Hank scored a point when he got him on the trial testimony shit. It's a shame. Shouldn't have happened. Shouldn't have happened. Thanks, Jim. Amy's positive pathways. Dr. Russell is retired, but still consults. Her brain is intact. Hank is supposed to wear the white hat. I hope Garrett Wing shows the bite suit arm. Yeah. Yeah. I'm not going to lie. I'm worried about Garrett. Just am. I mean, if you don't think that Hank's going to be pointing out the fact that dude was on Melanie's channel and that's how they found him, I got news for you. He is. Like, and if he hasn't testified before, You know, those things are all going to come out. And does that mean he's not knowledgeable because he hasn't testified in court? Of course not. However, the first time you're on the stand as an expert is intimidating. It just is. I'm worried about it. I'm worried about it. I mean, I've watched the thing with Melanie and Garrett, and he's super knowledgeable, knows his shit. There's no question about that. Dude's a badass. No question about that. Whether or not that translates into being a good witness is a whole different thing. But we'll see. We'll see. I mean, after the Russell cross, I assure you the defense is going to be talking about what they're calling Garrett Wing. That will be a conversation that is taking place. I promise. Thanks, Amy. Mickey, I agree. Bob, ground level with some claw holds and bite. Yeah. I mean, like, you know, the concept that like somebody's just standing there allowing a dog to gnaw on their arm is utterly ridiculous. I mean, like all of us, we'd be like moving around. Like, I mean, you'd be trying not to get bit by a dog if you're upright. Kicking the dog in the face. I mean, if the dog's attacking you, you're defending yourself. You're not going to be just standing there letting a dog gnaw on your arm. It's not the way that thing would go down. Thanks, Mickey. Lori G. Also, bottom teeth may not penetrate the sweater. True. Especially it doesn't get a good grip on a moving target. So I take it she's taking everything under advisement. Okay, and thank you, Lori. Ernie, I'll say it again, best channel mods in chat. Thank you, Ernie. Thanks for challenging our potential biases and helping us avoid the echo chamber. Family hug. Oh. Yeah, I mean, look, I'm going to call it like I see it, always, you know? Like, I am obviously firmly of the mindset that Karen Reed is factually innocent in this case. Evaluating a trial is a much different thing. That's what makes what we're watching at certain points terrifying. That's why you guys get so upset. You know, the thought that this woman could be railroaded by all accounts what seems to be a hired gun prosecutor who has zero scruples is fucking terrifying. Just is. Like, we can't sit here and watch and pretend like everything's like peachy. Some scary shit going on here. I mean, watching somebody potentially get railroaded is fucking horrifying. Should horrify all of you. Horrifies me. I mean, when I'm visibly upset, it's real. I'm not acting. Oh, are you coming in? Did you see any of that shit? Did you see any of that with the dog? With the
I saw a lot of it. I was like, man, their case is over. It's done. And I still think it is. It just kind of sucked that he himself, like, I have problems with my memory.
It's not right. Like, that's what I was trying to explain to the people. I'm like, it doesn't mean that he misremembered what he saw, but it puts his memory into question because he like. And
well, the worst part about it,
the defense team. They should have. You do not guess an answer if you don't fucking know. You don't do it ever. And he didn't know. And he was acting like he remembered crystal fucking clear, and he didn't. You know, like all it did was create this issue that shouldn't have existed at all. Did you guys see Allie's new eyelashes?
Stop.
Wow.
Well, while I was in there getting my lashes for the wedding done, I one earbud in listening. So I told her, like, if I like shout out or I scoff
Don't be
or I laugh,
startled.
right? She's like, oh, it's fine. So I was like, I was getting so frustrated. I was like tapping the table, tapping my fingers, like I wanted to scream, and I can't open my eyes. It's not like I can message you guys or say anything. So it was fucking killing me. I can't even remember all the things about it that were killing me, but that was during what it was mostly during
Russell.
right.
Yeah.
And then I was listening to this while I went back to have them fix the lashes.
Yeah, I mean, I was like, this fucking thing's over.
They were too big.
When when Barrows
Yeah.
puts up there, I'm
But
like,
the biggest
"Come on."
part, Bob, was why in the hell did he say that last picture is consistent with his memory?
No idea.
I mean, the answer is I can't see in that picture. That's
Right.
like I can't remember. Was that picture taken in the Reed's driveway right at the same
No.
time? Right. So
Well, he said that. He's like, that's not the Reed's driveway.
I know, but why didn't he say,
Why didn't
there
he
might have
say
been
what
less
all of you-
snow when I saw it. I can't tell what it is there.
Why isn't he just saying, I can't fucking like, why are you people all acting like this is a clear picture of something? It's taken from a great distance. Now you've blown it up, and I can't see what's what. I don't know if that you're acting as if that's an empty fucking like light cavern or whatever the fuck you call that chasm that's there from the taillights. Like, I have no idea what I'm looking at there. Is it snow covered taillight or is it
right?
Yeah, it was
And
like
I was surprised that they didn't. Okay, did he or did he not? Did Jackson or did he not? I kept putting in chat. I don't know if you saw it. Say, did the driver was he there when the driver did a 3-point turn?
no,
When
he didn't. I
but
thought he
was-
was going to. I thought that's exactly what he's going to do. Like, I thought he was going to show the whole video of them backing it out, getting into position, and then driving up on the toe, and he didn't do it.
Did he drive in reverse and all that snow and blah 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 whatever?
I mean, he did
but-
like they didn't get into any of that. I was thinking the exact same thing. That would have been a perfect opportunity to do it.
But here's the thing
David
about-
James, I'm not a lawyer, but is it possible that he's saving the challenge for redirect?
Right. I guess that he put that up.
This is from earlier this morning. So
Yeah.
this was, I mean, we know now. Not really. He didn't, it didn't really get addressed the way that I would have hoped it would and redirect.
I just want to say something about recross. And I know you said it, babe. Like, it's not like recrosses don't happen. What drives me insane is that after they're done their redirect, the judge isn't already saying, okay, thank you. Like, she's just sitting quiet, assuming Brennan is getting back up again. Then after the recross, she turns right away, where in every single trial where someone has done a recross, the judge has turned to me and said, anything based on that?
Right.
You know what I mean? Like, I have never had a judge and she does it every time. So it's like, it's yes, I hate that he takes the recross to just say the same thing again. That's not allowed. That's not what recross is for. Recross isn't for unhabilitating your witness, fucking them. You get to rehabilitate, and then they don't get to say the exact same thing again to undermine what you just rehabilitated. Like, that's not the way recross fucking works. But it's just like she never challenges him on it. She sits there silent for just allowing him to go. And
right, like assuming he's going to recross.
Right.
Like, recrosses are not standard fare. Like a lot of time, you're having to kind of like talk
the
the
judge
judge
is like,
into
Your
it.
Honor, I just have a couple things
Right.
based on that. And I think we saw that during the defense's case, where they're like, if they wanted to recross, like, Honor, I just have a couple things based on that. And like that's what we as lawyers usually say when we're seeking to recross. We have a couple things based on that. But anytime there's a recross, the judge will turn to,
Whoever was directing that person and say those words, anything based on what we just heard.
Right.
And it's like with
and
Hank,
sometimes vice versa for
with Hank,
recross.
it would be a vicious circle.
It's just never ending.
Because he's simple, like you said, he's simply re-asking the same thing that you just rehabilitated. So then the redirect would be rehabilitating that question again, and then Hank will get up on a recross and ask the question again, and then whoever's redirecting will have to do a redirect and ask the question to rehabilitate. You know, I mean, it would never end. It would be the same shit.
I don't know. You guys out there, like Bob and I don't have time to listen to other creators after this, other law tubers. If you're listening to other people out there, is anybody as pulling their hair out about the recrosses?
It's annoying as shit. It's annoying as shit. So last comment, David James, is it me or is the defense actually making the argument for Karen's innocence?
I think he means the prosecution.
Yeah, I don't know, David, if you're here.
What time was his comment?
It was early. It was 9:49.
Oh, babe. Yeah. No, that's why you got to go through them more in time.
Let's see. David, plastic would make larger gouges than glass. Yeah,
I haven't heard anything about glass really, other than on the bumper.
Glass. There's no glass. There's no glass in those taillights. The light bulbs are LED. They're not glass. There is no glass. It's all plastic. Yeah, no, like that was like you were gone for that. That was incredibly frustrating. Like Hank was showing some fucking random exhibit.
I remember. I heard you.
With giant chunks of plastic.
And you were like, "That's not the scrapings."
There wasn't.
Right.
It was like a complete misrepresentation of the facts in the case. It's like, so if those things were embedded in his hoodie sleeve, could those? I'm like, what? Like, are we in crazy world? Like, what is happening?
I can't wait to get to someone's question about the mistrial thing because I'm ready to talk about that again. But I'll wait because I'm sure someone posted a.
Welcher's due back in rebuttal. Maybe there will be another opportunity. Did he consider all the butt dogs?
Exactly.
Yeah.
No, and I do think and that's Jennifer's going back to Bob's comments before. Like, I wish this was more like the cross-examination of Welcher about all the things he possibly didn't consider.
Anything. Question him on anything. Like there was no questioning on any of it. Starting with the 8 mile per hour thing, and then like nothing about how he has reached the conclusion that we live in the Matrix and somehow that taillight shattered, froze in place, scratched his arm, and then he moved his arm a little more, scratched it here.
It moved, babe. I mean, it might as well just move this way while we're in the Matrix.
Might as well.
But to your point, babe, how many times did Welcher not know the date of something? He had to have his fucking computer, iPhone, wristwatch. He needed a constant flow of information to him to remember a goddamn thing.
His fucking shoe phone.
I apologize again.
Like he had all the help,
all the
Get Smart tools with him up there.
Thanks, man.
Thanks.
Yes.
Christy Silo is on notice the same as put into evidence.
No, hell no. Now this is talking about, is 10-11 too soon for the mistrial, or is that about where we were at? About the DNA? I think that's what she's talking about, because that's where the words notice came up and put in evidence.
Yeah.
So here is the thing about that. What I was kind of commenting on was the sort of underlay of Alessi's comments, because he's like, I would have objected and objected. So I was noting that it was clear the defense had come to the decision that they were going to be able to prevent the prosecution when whatever that expert's name is that he mentioned got on the stand to testify about dog DNA, that you never put any swabs or the fact that dog DNA was even found in evidence. So now you can't have this guy testify about how there was no dog DNA, like that was what was in their mind. But the notice issue is definitely different than being put into evidence. It's two completely different things. But when you going back to what they were saying at that point in time, which is different than what I was sort of thinking ahead for of their intent to object on rebuttal, there were no facts and evidence. There were no facts and evidence. And one of you commented, I'm sure multiple of you commented in chat about that, but I put up somebody's comment, facts not in evidence, for him to ask her about it at that moment in time, because there were no facts in evidence about it. So no, it's not the same. It's not the same. And the judge let it all happen. She said he can ask her about it, and he's getting to do it in rebuttal.
And just so you guys know, when occasionally you'll hear them say that they're marking a particular exhibit, and for identification, that does not mean that the evidence is in evidence. That just means they're going to be using it at some point. That doesn't mean that particular evidence won't get into evidence at some point, but at the time that they're marking it for identification purposes, that does not mean that particular piece of evidence is in evidence.
And if you remember, Bob, there was an occasion, I just remember your comment in my mind, where during the state's case in chief, he had to redirect to get all the stuff into, or after the witness left, he moved the stuff he marked into evidence because he had forgotten to do it.
Yeah.
Brennan. And you're like, oh, well, they were letting him fix the fact that he forgot to actually marked it, but he didn't move it into evidence.
Yeah, that was that was like the timing of that was like too late. Like,
right.
It was,
too bad, too sad.
Right.
People do get fucked on that. Look,
you know what it was? It was after they rested.
No.
I think so.
She let her do it after they rested?
I thought there was
No,
something.
I think
like,
it was after a witness was
he
over.
rested and came back after lunch, and there was something that she let him do. I swear.
I don't know. So is either that
my
or
memory's
after a
like
witness.
Barros's, and that was only like a week ago. So there you go.
Well, and mine, we all know where mine is, but I still think it was after a witness. But
unsolved mysteries. Somebody hold my hand virtually. I'll give you family hugs. Thanks. Unsolved. Mickey, this is above my head. What's the odds? Is this because it wasn't brought up by the defense during the case in chief?
It was.
This is related. That's again
right.
related.
The odds were always, as Bob said at the time, not happening, and it was because it wasn't brought up during the prosecution didn't put it into evidence, even mention it in their case in chief. All they said is they swabbed, but they never said what for or what was found or dog DNA. And then, as Bob pointed out before, the defense didn't mention DNA at all with that witness. So why was he getting to do it? But if you bring up a witness's opinion, things that challenge it, even if you don't mention it, might.
I mean, my problem with it is that the defense didn't have the opportunity to cross-examine anybody about that. Any of that information. There was no confrontation clause shit with it because.
Well, there will be in rebuttal.
Wait, when?
Well, that's when the state's going to bring it into evidence, is in rebuttal.
With Walsh?
They're going to need to do more than Walsh, and I think they know that now. Now that this objection's been launched, they need to get it in with the DNA analyst that actually tested it, swabbed it, sent it.
Maybe. I don't know. But typically you have the right to cross-examine somebody who's saying I there should have been a tech that was on the stand that was getting crossed about what they swabbed, what they didn't swab, where they swabbed it.
I think
all the shit that we saw in the first trial.
I think they did get the fact that they swabbed, not what for, like whether it was for DNA or whatever, just the fact that they swabbed.
Who would have put that on?
I think. Don't hold me to it.
Yeah, I think
but they definitely didn't say, and we sent it for DNA testing, and we tested for dog DNA, and we or anything about DNA. So
my point is that there should have been a witness that they could have cross-examined about that issue before they could just bring it up, asking a bunch of questions about it. But
right.
Just Jim, member for 2 months, no other place I'd rather be. Thank you, Bob, Mods, and Allie. Thank you, Jim. We love you over here. Johnny Miller can't use DNA because defense couldn't.
There you go.
There you go.
Bob just said.
I agree, John. I agree.
But I'm assuming that they're going to. If they were not to on their
I
rebuttal,
don't
then,
know. This seems like the Wild West to me.
then she'd have to strike it in a retro spike, and be like, "Well, you guys never did that, so all that testimony about DNA with
Who gives a shit about retro striking? Like, that doesn't work.
I know, but I know.
Hey, this isn't like the Men in Black with that fucking tool they have to get people just.
Laura
to feel
says
like,
Hank isn't calling the DNA expert through the entire case. I guarantee you, after this objection, he's like, "Oh fuck, I better do it," and he's going to. I
thank you.
think.
Gifted 5DD memberships. Oh, family hugs. Unsolved coming through in the clutch. We appreciate you so much. Lana, family hug. Welcome. Welcome, welcome. Amanda the $10 super. Appreciate you. Mickey, DNA is important. Words during trial and serious if brought in the wrong way. Can't take those words out of juries. Yeah, that's exactly what I was just saying.
And that's what Alessi argued.
Yeah. Well, I mean, you can't unring a bell.
Right.
You know? Like there is no, it's irremediable. You can't fix it.
And if they don't introduce that evidence and call a DNA expert this entire time, then they're going to have to rebring that motion because, you know.
Thank you, Mickey. Unsolved comes back with another 5DD membership podcast giftings. Woo! Thank you. You're the best, Unsolved. Family hugs. Tony, in honor of badass women like Dr. Marie Russell everywhere, Allie obviously included here. You're here.
Thank you.
Mickey, what are the odds that Hank makes that same mistake multiple times during cross of others? Would that change Bev's ruling eventually? One too many times. Doubtful.
Which mistake did he make? Did he mention trial? Did he mention FBI? You don't remember?
He's said trial multiple times.
Right.
He has said trial multiple.
And maybe she means if he brings up DNA again. Then
Mickey, if you're still here, flesh it out for us in chat.
It might be that because it's back around that time.
Michelle DeFala, the DNA was negged because it wasn't tested.
Except for animal DNA.
Yeah, pig DNA, pig owl pig. Thank you.
Owl pig.
Larisha, my stepdad is a German Shepherd, lived with us, had to be locked up when we were alone. He bit my sister 2 times.
Oh.
She had scratches and deep punctures, clearly went after her arm since arm was the first line of defense. Absolutely. Dog more viable to me with my own eyes. 100%. Like, there's nothing even remotely commonsensical about the concept of the taillight. Like, it doesn't make any sense. Like, I don't know if I'm describing in a way that y'all understand.
No, we get it. You're saying we're in the Matrix for that shit to happen.
But like, the thing would have to stop. Like, it explodes and then stops like this. And then his arm drags across it. But he's getting hit at 24 miles an hour. Like, the Blue Man Group was standing right behind it. If that thing was going 24 hours, he would have been plowed over. There's no rolling out of it. You don't roll.
Yeah, with the little fancy footwork. Did you see his fancy footwork? He had fancy footwork.
The whole
He could dance right out of that shit.
It's fucking insane. It's insane. Thank you, Larissa, so much.
Thanks.
Cyan, Bloor, remember 2 months. Or do you think that's Cyan? Maybe.
Cyan.
Cyan. Let us know if I'm fucking it up.
I mean, the Enye thing.
Didn't they put frags in the same bag as clothes? Sure seems like it.
It was definitely something that was
shook the bag around
alleged.
real good, like you're trying to get some shit breaded. Trying to bread these chicken wings. Contrary Mary, family hug for Bob. Aw,
yeah, Bob needed it.
one. I needed one. I was like, I felt like pretty homicidal during that early morning session. Just not happy. Thanks, Mary. Kyoka, I did get your email, by the way. Thank you, Bob, for making me look at things differently. Well, thank you
for appreciating
being
that.
open-minded enough to look at things differently.
All right.
That's hard for some people, hard for a lot of people.
A lot of people.
Thank you. David James, backside of his arm, wounds there. I mean, that's the whole thing with the gripping. Like, did it grip? It's like,
oh, that was another
That was
thing.
Lally's whole thing. Like, doesn't a dog have a lower jaw?
But here's something I was
to see the lower jaw.
It's like,
here's something I was thinking about that when he was like, "There's no standards, and we're not talking about his stuffy nose." How many times is it you've got finger marks or on someone's arm, whether it's a domestic case, a child abuse case, or even a cop case? That they're like, well, you see the fingerprints right there. You see the 5 fingers. You like, do you need a standard that says, well, what you look for is bruising this direction, spaced however far apart, because somebody can have their fingers like this or like this. I mean, it was, I
5-finger death punch.
yeah.
David James, why not put a rubber arm side by side to highlight? I'm imagining.
Or to the.
I mean, I'm big on demonstrative shit. I think it's helpful for the jury. So
Right,
point
or
well taken.
side by side with the taillight.
Jennifer J25, thank you very much. Appreciate you. Norman Corey. Hank just got bit in the nuts. D's nuts? D's nuts.
Wait, what time was that?
That was
at
at
1:45. So
1:45.
right after lunch.
D's nuts.
That might have
Okay.
been. Yeah.
Close. So 2 MEs couldn't determine the cause of death. Plus, Russell also said no collision. Insane that this sees the inside of a courtroom. Agreed.
And even more insane once you get that last witness on the stand.
So this is right after Barros dropped the bomb.
Yeah. Right. So that's what I think that's what Norman Corey was saying too. Hank's just got bit in these nuts.
I was like, what? I'm like, this shit's over. Still is over.
It's still over because it's reasonable doubt.
Right.
His testimony was much more powerful this time because they did put up that picture.
Well,
and
and
do
what
that
the
whole
other
thing.
thing that I was saying is that Hank, because he understood how devastating Barros's testimony was in a lot of different ways. It shines the light on Proctor and all his fucking shenanigans. But the biggest thing is it makes it impossible, the arm injuries that he's suggesting happened, if only one piece of the taillight's gone.
Right.
The time that Barrows sees it. So what Hank did, babe, is he blew his entire load of,
Are
when
you
you're
doing
cop,
a load hand down there?
You got to do like a real thorough report,
doing a
right?
load hand.
And you got to take like he threw this guy under the bus for all of the shit that none of his cops did, which is going to come home to roost. It just is. But he had to use it to try to put some shit on this guy.
I'm sorry.
What?
Nothing. You missed it. I'm not repeating it. It was bad.
Oh, was it like the hand gesture?
Yeah, I thought you were because your
Yeah, he was
arm.
blowing his load.
Oh, you were you
Blowing his
actually
load.
doing that under there? Okay.
Yeah, he blew his load.
All right.
Try
All
not to
right.
be,
Oh
had
my
to do it off
goodness.
camera.
Oh, speaking of getting clipped, and I meant to text Mandy and Tracy. We got to take the arms out of today so we don't get demonetized.
I mean, that's not what it is. Like
What?
don't worry about it.
It's the arms.
It's not. It might be the arms, but
Well, we're taking them out.
how are you taking them out? Just gonna
I
blow
don't
them out?
approve of not making money.
Laura, 4181. Bob, where did he come from? He wasn't in the first trial.
Where
Are
did
you
he
talking
come
about? I
from?
think
Where did he
she's
go?
talking about Walsh. So Walsh was a guy that they litigated against.
All right, Hank.
Easy for me to say. Litigated against in motions in limine, and I think ultimately Canoni's allowing him in, but only in rebuttal, and that was based on Hank saying that they only intended on calling him in rebuttal.
Right.
So, and she was limiting what he could discuss. So that's where Walsh comes
That's
from.
their dog guy. Their anti-dog guy.
Yep. Mickey, great after Dr. Russell. If they was questioning her a little, now they believe her.
Right, meaning that officer, because you made that comment like, I would have liked to see him first, maybe, but he was great after Russell. She thinks so too.
Yep. Thanks, Mickey. Can you hear me losing my shit in Scotland?
Did you
Yes.
hear me losing my shit in
More importantly, I can
Avia?
feel it. I can feel it right here in the great state of Illinois. Thanks, MJ. Meg P, best chats, mods, and hosts ever.
Like
Aw,
you,
thanks.
best mod.
You're biased, Meg. But we love you. We love your bias over here. West Jojo. Right, Bob. This is what it looks like when a witness has no dog in the fight. Someone needs to inform Welcher.
Yes,
Agreed.
they do. Sorry,
Thank you, West
400
Jojo.
grand's it's like the biggest dog. I don't know what it's like a whatchamacallit. What are those?
Can
Whatever.
Bev trash this case? I mean, she's trying.
No,
She
like can she throw it out if that's what you're
well,
asking?
yeah, she could have thrown it out. She could have dismissed it, declared a mistrial
Yeah,
with
but
prejudice.
that was before. Oh, right.
This is way after that.
Right. So no, not right now. She can't be like, all right, that guy does it. It's out.
Yeah,
No.
she's like, it's over.
But they can make a motion for a directed verdict after trial. They renew their motion, and
It would
she
have been
could do it then.
stronger had he not tripped him up on that stupid trial shit from last year where he should have said, I don't remember.
As far as I'm concerned, don't forget that Massachusetts standard says if there are two equally plausible possibilities, that's reasonable doubt, like that a verdict cannot stand, that no reasonable jury could find guilt if there's two equally plausible scenarios. And I think that's been proven. Equally plausible.
I did too.
And we're taking it at best for the prosecution. They're equally plausible.
And I don't give a shit what anybody says. My slip and fall coyote thing's just as good. So I'm going to argue there's three. I don't give a shit what you guys say.
Dude.
West Jojo, I love Sarge. Joey Jackalone. He's the best. He is. We love Joe over here. I'm so glad he's back. My guy, Joe. We portaled y'all to Joe's show tonight. Let's go check that out. I'm going to be on there pretty soon. We're just trying to figure out scheduling. I had Joe on right when he came back.
Wondering what I'm doing. I'm sort of
Stinky cat. Oh, stinky cat. Hank makes my ears bleed. Sit down, Hank. It's over. The jury ain't buying your feeble attempt to discredit Barrows.
Agreed, stinky cat.
Stinky cat. Oh, stinky cat. Thank you so much. Larisha, Bob, can AJ play trial 1? This officer said he cracked, not broken. Yes. Hello. I can completely envision that Larisha's like always screaming at her screen, like many of us are. Like we just happen to have our cameras rolling when we're screaming at the screen. I'm sure everybody at home's doing the same shit. Well, to me, he doesn't need the photo. I know what you're saying, but like it was a finer point than that. He was trying to demonstrate that this guy's memory is not perfect because you know what? No one's memory is perfect. So like that was what he was trying to do. And he was able to accomplish it because this guy wasn't coached up. They're like, hey, if you don't know an answer definitively,
He's a cop.
for the love of God, don't answer.
He's a cop. That's the last person you think you need to help.
No. Sarah, are lawyers not allowed to talk to their witnesses? Like leading into trial, of course. I mean, you can't tell them what to trust, like how to testify. Like, this is what I've written you a script and I need you to say exactly these words. That's not what it is. But like if we have our questions ready, like we can read through them just to hear how they're answering them. So yeah, you can obviously talk to your witnesses.
But every single prosecution witness that and I'm sure Bob, you do the same thing, cross-examine, I always ask, when's the last time you talked to them? Who did you
100%.
talk to? How many
You want to
times
know how
did you talk
prepped
to
they
them?
were.
It just does what Hank was doing. It puts like a little bit of, oh, really? And if it's right after lunch, you can bet your ass that I said, so did you see him in the hall? Did you talk to him? What'd you guys discuss? Who'd you talk to?
Yeah, like I mean, the whole thing with them talking to her about asking for a transcript. I mean, technically, they probably shouldn't have done even that because she was still on the stand. She was still under oath.
Right, and it's about how she testifies. I was like, well, that's not about her testimony. Bob's
Right,
like,
it's not about the testimony
about
directly.
What she's doing while testifying. So
Right, it's like critiquing. It's critiquing. Yeah, you don't want her answering that, but she's an honest lady, so she said, "Yeah." Jennifer L. Doesn't Barrow's memory align with what we just saw in the video of the Lexus being put on the tow truck? I think it does.
Yeah.
I completely like. I agree. The most damaging part was not even the memory thing. It was the thing that Allie came on
Yeah.
saying, like, why are you saying that that's what the fucking taillight looked like when you saw it?
Talking
'Cause
about
number
the
one, you
picture would have
can't
been
see
snow
what it
covered.
looks like.
Right.
You're like giving that photograph credence as if it really shows something. Clearly, it doesn't show anything. I can't make out what it is.
And I
The
would have
taillight, like, is it like I still see the bump out? So to me, it's just the taillight covered in snow. So
Right.
I don't know.
Yeah. And I would have pointed out on redirect that when he first asked you the question about whether or not you made the distinction between the photo like you are now, you answered twice, maybe 3 times. Did you answer twice or 3 times? I don't think I was asked that question. And then when he pushed, did you answer like that because you assumed you must have been asked and you knew if you had been asked, you would have answered that way? Oh, and I also would have said, well, as far as whether or not you made a distinction between that photo, you testified it was chipped, not broken. Is that a distinction between the photo? Is that different than what's in the photo? Yes. You know what I mean? Like, you didn't say the words, but you again weren't asked the words, because that part's true. He wasn't asked that question. Yeah, he didn't say, well, it didn't look like it does in that photo, but he wasn't asked that question. But he described it in a way that was distinctive from that photo, in that it wasn't freaking broken all the way.
Oh, that was freaking me out. I was like,
What?
like, why can I see like outside, like into the street, like on your screen? I
Oh,
just
because
realized it was the background.
background.
I'm like, what the fuck
I was
is
doing
that?
the same thing with the flag above my head. I was like, is that an American tie? Like, why is there a light American flag like thing?
that
above
an
my head?
UFO?
Is that
What
an
is that light?
See that light just disappear?
You guys don't understand how many times Allison sees UFOs every single night that we're driving.
No.
Oh, please.
Stop.
Every night. Like, when's the last time we took a drive that you haven't seen a UFO?
That I haven't been looking
What
in the
is that?
sky.
What? Where'd that thing go? Oh my God. It's a plane.
I'm gonna.
And I'm a big UFO guy. So wait, did I read it, Larisha? So
did it
Bob Alley
earlier.
said the other day. Oh yeah, I did. And thank you
Thank
again,
you.
Larisha. Rebecca writes, ugh. I feel like the defense team is getting killed by Brennan this time around. Do you think a guilty verdict is more possible than last time?
I don't.
I don't
Personally,
either,
I
but
think that Barrows just, I don't care what he said or changed or did. He created reasonable doubt. to me.
Here is where I live with this case. Like, and this is my honest, like, deep down feeling. I think they could try this case 1 million times and they're never going to get a verdict. I just think there's going to be people that buy whatever Brennan's selling. And I think there's going to be people that buy the fact that there's reasonable doubt, and they're never going to get 12 people to agree. It's one of those cases. I think it's just a case that 12 reasonable people are never going to be in agreement on it. That's how I feel about it, honestly, which is a fucking shame. You know, because if they just follow the science, because like Hank, that's why y'all are getting so upset. It's like the shitty little things that they keep doing to just kind of push this shitty case forward are going to be enough for a couple people to be like, yeah, you know what? Like, I think she might have hit him. You know what I mean? And then you're going to have the people who are like, are you fucking out of your mind? Didn't you listen to the science, bro?
Right, but I think those people will have enough things to point out.
No
about
one's changing
reasonable
my
doubt.
mind on what I just said. I am predicting we're not even done. And I have no doubt Ark is going to get on the stand and knock it out of the park. And it's going to end in a mistrial. That's where I'm at. I just think this is a case that is never, ever going to get to a verdict because it's like, there's too much. And like, all right, I'm going to give one proviso. Unless Alan Jackson pounds into their skulls
like Mark Betterow and I and Allie were talking about what the concept of reasonable doubt means, so that it's like unequivocally clear what reasonable doubt is. Unless that happens, if he mentions it a couple times, it's not going to be enough. Like, they have to clearly understand what reasonable doubt is. This case is reasonable doubt. The whole thing from front to back is reasonable doubt.
Yep.
Thank you so much, Rebecca. Dot
Guidici.
Guidici?
Guidici.
That Guidici.
Or that's one C. So is that different?
Guidici. Yeah.
I don't. We want it to be
Guidici.
very Italian, but
well, that is definitely an Italian.
Guidici.
Right now,
Is
man.
one C Guidici? I don't know.
I like Guidici.
I do too. I do too, but I think it needs 2 C's for that.
It's
All right,
nice.
mistrial with prejudice. Boston 25 reporting there, asking, love you, not guilty because of DNA. We saw that. Thanks.
Didn't happen.
Didn't happen. We'll see if the appellate court.
No one was surprised by that, right? Michelle, $10, $10 holla. Can we talk about Brennan saying over here after an objection to Barros and Jackson calling it out? Yeah, it was fucking.
What happened? I missed that part.
He called for, it was right before a sidebar. Jackson was over here objecting. Barros was looking over at Jackson because he had just objected. And Hank's like, over here. Over here.
Oh, it's kind of like we say we do.
Go to the sidebar, and Jackson's like, really? Over here? Like, it was a little tit-to-tat. It was off camera, but you could hear it.
Oh, it was Brennan saying it to Jackson.
Yeah, no, he was saying it to the witness. Over here, look at me, over here, because he was looking at Jackson because Jackson just objected.
So I was saying that's kind of sometimes what we do when they are looking at the prosecution. Like, excuse me, or we, like you said, we'll stand in front of
right
them,
in front of
block
the
their
prosecutor.
view.
Make yourself big. What are you looking at? Are you trying to make eyes at the prosecutor? You're looking to them for help. I mean, we've both, Allie and I have both said that shit out loud prior, like asking them flat, like, are you trying to get some help from the prosecutor right now? Thank you so much, Michelle. We appreciate you.
Wait,
Cody, can you tell me?
Oh,
can you tell me what he changed his testimony on? I don't think he changed his testimony. I think he fleshed it out a bit more. Like, I think he gave a more thorough description of what he saw in terms of like the piece, size of it.
Right. He fleshed it out.
Dollar bill. He fleshed it out a bit more.
Hank, though, he's the gaslighter. So Idiot Win said, does
That's
not
Proctor.
calling Chip make sense now? Yeah. Bob mentioned that right afterwards. Like, there you go. So great minds think alike. There is this little freaking
Mayfly. Norman
even.
Corey, did you see those 2 pictures that Chris sent us?
My God.
I about lost my shit. I'm like, you got to be.
I told him, turn all the lights off in your house.
No, so those were fake. Those weren't real.
Oh, he was
my God.
messing with us.
Yeah, well, you must not have seen that. So, like, the wedding's on Saturday, and they get mayflies because they live right off the Mississippi River. And so these mayflies, which appear in May and can be super annoying. And, so we were all worried about it on the drive home. We're like, oh my God, there's going to be mayflies everywhere. It's an outdoor wedding. We've got a tent and lights and all this shit. And so my buddy who lives down there was sending us these pictures. Like, oh, here's the neighbor's car. We keep ours in the garage. But here's our neighbors who don't. And the car was covered in some kind of insects. He's like, here's the gas station right down the block. And it was like 3 inches thick, dead mayflies.
But do you remember? Do you remember when we were in Detroit one year for Jacket, and it was like snow covered the ground because it was so white? We were stepping on all the dead mayflies, and every light outside of the bars was just swarmed with them.
I do remember that.
Like swarmed. Yeah.
That's where I had like the best chicken shawarma I've ever had. It was delicious. I'll never forget that shawarma ever. Norman, thank you. The white blur in that video is the snow blowing by the camera, not the tail light. That's why he stops the video in the same spot. Agreed.
Agreed.
Like,
He's
look,
a
man,
scumbag.
none
He's
of those
scumbag.
fucking pictures show me a goddamn thing. I'm
No.
sorry, they just don't.
No.
Like that's why, like, everybody that's involved with this trial from the Commonwealth side pretending like they're crystal clear pictures is absurd. Like,
Right.
if we were defending this case, I'm like, how many times are you going to act like that's a clear picture? Can we quit doing that? There's nothing clear about that picture.
And like Hank pretending that the tech stream or whatever they call it, if you didn't consider that, then you don't know she went in reverse.
Or
Doesn't
like
prove there
Hank,
was an
like,
accident.
crossing Dr. Russell
That's
as
what,
if like the collision is a fact.
Right. That's exactly what I'm saying. Yeah.
like, wait, dickhead.
Right.
That is not a fact.
No.
Quit acting like that.
That's why I'm saying I want the defense to do the same thing. Be
I
like,
know.
well, did you know that there were some people hovering around that tail light in the Sally port and all the video went missing and then they gave it inverted.
Right.
Oh gosh.
Right.
No.
Somehow it all magically showed up in the field of debris. The debris field that was created by Proctor. Oh, God. Joe Schmo, member for 13 months. Joey Schmoey. We love you, buddy. Lucky 13. Love hanging with Bob and Allie. Oh, are you all heated up? Is tomorrow the big day for Lori Vallow 3? Schmo's always Schmo typically covers those in
Skipping
person.
it this year. That's not happening.
We're not covering that one. You'll have to
I don't
go.
know what you're planning on doing Friday because it's not this, babe. So you
What?
better have someone backup planning you for Friday because you're
What
not
do you
doing
mean?
this.
What are we doing Friday?
Our daughter's wedding, rehearsal dinner.
Oof.
You're lucky to be able to do it Thursday while we're supposed to be we're supposed to be doing all the last minute things around in Iowa.
Oof.
That's why we're
Oof.
going out there Wednesday night.
Oof.
Oof.
I have a feeling I'll still be on Friday.
No, you won't be on Friday.
I feel like I'm going to be
Stop.
on Friday.
No.
Barry Holt, my partner punched our neighbor's dog in the face as it jumped up towards his face, trying to bite him. We're not going to stand out there and be bitten 100%. Like, there's no question. Like, I'm running, trying to jump on the top of a car. Have you guys ever
Putting
had
your
to do
arm
that?
out.
I've done it where I've seen a dog start like chasing from a distance and I'm running. I'm like, oh my God, trying to find a place where I can like get up where the dog can't get me. And I've had to
Climb a tree.
I climbed up and got on the roof of a car.
When did this happen? Your high
Well,
school?
I was like in high school, yeah. Thanks, Mary. Idiot Wind, Hanky, Memory Fades. May Karen Reeds have? Quite a ponderable.
Quite a ponderable. Thanks.
Tracy, thank you, idiot. Hank with the memory issues to the good doctor pissed me off. That was very insulting.
He
Pissed
did
me
that
off.
before. She had to gasp during either trial or
You didn't even see this
I
gasp.
didn't, but I remember a gasp during a voir dire.
She went like this. It was like she was like
And did
she was
the
so
judge
taken
say
aback.
anything? Was there an objection?
No, nothing. Tammy Martin, that was rich. Hank lecturing the last witness on detailed reporting. Laughable.
Yeah,
no
right?
shit. That's what I'm
doesn't
saying. He's made his
it.
bed.
Yeah.
Thanks, Tammy. Better Rose fangirl. I'm scared to death. She's going to be found guilty. Please tell me I'm wrong. I mean, you're wrong. I think it's going to be a mistrial, but I hope she's found not guilty, obviously.
I had some
but
fears
it's
early
like,
on
and it's
during the
not, it
state
has
case.
nothing to do with the witnesses. It's just like one of those cases where if we look at society, like, and it should be the other way around because it seems like 80% of the country thinks that Karen's innocent and that the 20 think that she's guilty. So it should be like 10-2 NG and they can't get the two guilties over.
Right.
If it were to mimic society, I don't know.
Thanks, Decline.
Like if they follow the science and they understand reasonable doubt, it should absolutely positively, because none of this shit matters. None of it matters. Because the science is going to tell you that she was not struck by a motor vehicle or that John O'Keefe was not struck by a motor vehicle. That's what the science says. That's it.
Decline. Just because you are both so loved. Aw, thanks, Decline.
Thank you.
Love you back. Sylvia S. Dr. Russell had a good explanation for Karen's I hit him words. She called it grief guilt syndrome or something like that. She did. And,
Sure did.
she got to get into that because Hank brought it up.
Yep.
Like
Hank
if the
opened that
defense
door.
had tried to bring it up during
Would've
the
been
direct, it would
objectionable.
got shut down.
Yep. Bob knows.
Yes, I know. Idiot Wind. So much love. Plus these two commentators. Think you'd enjoy having them on.
Oh, so Tracy said she's talking about Oh Brother, I think. I mean, brother counsel. I'm sorry, Oh Brother. Tracy sent us a text. Brother counsel, that's who Idiot Wind is talking about.
Oh,
You're
yeah.
not the first one to say that. We don't know them. I guess we'd have to reach out to one another somehow, maybe.
Yeah, I've never watched their stuff. I know they're Boston based guys, or at least the main dude is. That's all I know. Thank you so much, Idiot Wind. David James, I found the Dever to be really unlikable. Yeah, we all did. She was a fucking slippery piece of shit. Larisha, I want to know about Allie's eyelashes. Do they bother your eyes? Answer them as the questions come.
Well, there's all of these. So I'm going to say, how long do they last? Is there a certain type of it to ask for? So they don't bother your eyes at all. They only last about 2.5 to 3 weeks. And, if you're going to ask for something, ask for hybrid. But I'm not good I can't do anything every 2.5 to 3 weeks. So I end up walking around looking like a crackhead with almost all the lashes out and a couple strands. I'll do it consistently for a while and then I don't. And then when I take them out, you already have to get used to oh, wow, don't have any eyelashes anymore. But I also think they damage, at least for me, that my real lashes get damaged and shorter. And it took them a while to get back to a normal length. And I think some of them fell out. And
all right. Hey, I love you guys. I had to go pick up Scout right now, babe.
Okay. Bye.
So finish. We have one more.
Yep.
We love you guys. See you in the morning, 7:50. Half day tomorrow. All right.
So I suggest the magnetic ones personally, because those don't damage your lashes. You can stick them on and off easily. You don't have to worry about glue. But thank you. Oh, also, if Hank gets up to recross again, I'll lose it. Yeah, right. And then Melissa from Montana. Bob, rewind today's trial to right as Dr. Russell is walking off the stand. Watch the court reporter's reaction. I don't know about this. Let's see. Should we do that? Is that a thing? Let's see if I can even get there. Right when Dr. Russell. Did she come back? Yeah, she's back. Dr. Russell. Oh, okay. All right. I'm going to share my screen because we're right here. I got it. Might as well pull it up. See what you guys think. See what's going on here. All right. This, are we talking about right here? Court report? Thank you. Wow, was that it? She does that. She definitely, she's like, wow, they really came at her. Thank you. It's like, oof. Ooh. Ooh. I mean, that's what seems like just happened there. Thanks, Melissa from Montana. And one more. We got I See You. The one Meadows photo is distorted and blurred. The Commonwealth is cheating again. That's why the Commonwealth shows it so quickly. Agreed. I think everybody agrees with that sentiment. All right, guys. So it's very unlikely you'll see me on Thursday. While Bob's not here, I guess we'll have to see who wins. And it might not be me. So it's as far as if he's going to be on I mean on Friday. But I mean, I guess if we get everything done, but I think he's not realizing that we've got other shit to do. We actually have to like build the hoopah. So we'll see. We'll see. Maybe Bob will be on Friday. I definitely won't. Wrong video. Melissa said that was the wrong video. That was when. All right. Okay. Let me go back. Let me go back to yesterday. It seemed like she put a she did a face that time. So let me see what I can find this time. After Dr. Russell gets off the stand. So at the end of the day, basically, is what you're saying here. All right, I don't see anything happening here, but I'm gonna entertain this thing and see what that seemed like a lot, but I don't know. Share screen.
It seems like it's a good place to break. I do have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. Got it, David? Thank you very much. Dr. Russell?
Yeah, we didn't even see the
Thank you.
court reporter yesterday.
Okay, thank you.
Unless it was.
Can I see counsel while the jury's filing out, please?
Upper arm, which is above the elbow.
This was at lunch.
And
Oh, geez, we got to take all these arms out. Lord, what'd I do? The heck? It's like right there. Arm on the screen, fan. Unless this is a sidebar. This could be just a sidebar. Long sidebar. Yeah, I didn't see anything when she got off the stand. Yesterday. All right. Sorry, Montana. That's all I got for us. I tried. All right. Nothing after I see you. All right, guys. Well, we will see you tomorrow. Thanks for watching with us. Thanks to all the mods. Thanks to all our members. Wait a minute. Let me make sure we didn't just get another super. No, we didn't. Okay. And thanks for being here. And yeah, if you find it, Melissa from Montana, let us know. All right, guys. See you tomorrow. Bye.